Good morning, everybody. Subcommittee of Oversight and Investigation will come to order, and it's an opportunity for each of us to give an opening statement, and I shall open with mine. President Obama's Executive Order 1356-3 states that agencies must take into account costs and benefits of proposed regulations, use the least burdensome method to achieve regulatory goals, maximize net benefits, and evaluate alternatives to direct regulation. The order also requires agencies to conduct periodic reviews of significant regulations to determine whether they are outmoded, ineffective, insufficient, or excessively burdensome. These retrospective reviews have been required for more than 30 years, and if conducted as intended, could be a crucial tool in reducing the burdensome of regulation in our economy today. As chairman of this subcommittee, I have set out to ensure that these goals are simply achieved. Regulations cost money, and in today's weak economy, we cannot afford such burdens when they are totally unnecessary. During our June 3rd hearing, Mr. Cass Sunstein of OMB indicated that although independent agencies were not bound to comply with the executive order, he believes that they should. Unfortunately, none of the independent agencies under the committee's jurisdiction have to date complied with this executive order. So we are holding this hearing today to ask the Cpsc, the FCC, the FTC, and FERC to explain why they did not submit a regulatory review plan to Cass Sunstein by May 18th. As they were asked to do. While each of these agencies engages in some degree of regulatory review, none of them conduct the kind of top-to-bottom regular retrospective review that will help to unburden our economy. The Cpsc, perhaps more than any other agency today, seems determined, in our opinion, to pass regulations without even a hint of regulatory humility. Commissioner Northup will testify that Cpsc regulations are estimated to cost industry billions of dollars, with no cost-benefit analysis done to simply justify those regulations and no analysis done to show improved safety for our children. Commissioner Northup has also submitted for the record today a list of businesses that have closed their doors, in part because of Cpsc regulations. Now, we realize many of the Cpsc's most damaging regulations are required by the CPSIA, which had a number of unintended consequences. Until Congress can act to reform that law, we would hope that Cpsc would use its discretion, where possible, to comply with the President of the United States executive order. Where Cpsc doesn't have discretion, we would hope the Cpsc Democrat commissioners would be cooperative in helping this committee identify where they need more discretion rather than sending last-minute partisan letters meant to derail the reform process. Meanwhile, Congress asserted deregulatory goals in regard to the FTC decades ago, removing its authority to operate under the Administrative Procedure Act and instead instituting MAGMOS procedures, created under a Democrat Congress to halt the agency from further significant rulemaking. Today, the agency resorts to rulemaking through orders and guidelines that do not undergo a notice and comment process. Although FERC does not issue a large number of regulations, there is room to improve in its rulemaking and regulatory review also. FERC regulations call for broad ranges of data sets without a clear indication on how the agency utilizes this information. It has not conducted a top-to-bottom review of its regulation since the Clinton administration. And it's unclear what, if any, cost-benefit analysis is done of the impact its policies have on the energy industry and consumers. Now, as for the FCC, in drafting both the Communications and Telecommunications Acts, Congress emphasized the importance of deregulation. The FCC is required to review its telecommunications regulations every 2 years, and its media ownership rules every 4 years. But these reviews fall short of what the President and this committee have asked agencies to do. They only cover a narrow set of rules at the FCC. The Commission can't seem to get these reviews done on time, and the Commission hasn't repealed or modified any significant regulations in recent review periods. Perhaps that's because the Commission is too busy taking conclusions-driven actions, such as a net neutrality order and the Chairman's Section 706 report. So, my colleagues, I look forward to learning more about what each agency will do to adopt the principles of the President's executive order. I hope the format of this hearing gives you all the opportunity to learn about what other agencies are doing to improve these processes. And with that, I yield to the ranking member, Ms. DeGette.
Thank you so much, Mr. Chairman. This is the fourth in a series of hearings examining the government's regulatory review process, and I frankly am pleased to hear you today embrace the President's executive order that sets forth principles of regulation protecting public health, welfare, safety, and the environment, while at the same time promoting economic growth and competitiveness. I thought that Cass Sunstein was an excellent witness talking to us about how we can all agree on a bipartisan basis that we should eliminate unnecessary regulations at the agencies. Now, today we have witnesses, and I'm happy to welcome all of them, particularly our former colleague, Congresswoman Northup. These witnesses represent four important independent federal agencies: the Consumer Product Safety Commission, the Federal Energy Regulatory Commission, the Federal Communications Commission, and the Federal Trade Commission. Now, Congress created these agencies as independent agencies, and so therefore, as you noted, Mr. Chairman, they are not covered explicitly by the President's executive order on regulatory review. But it's important, though, for the subcommittee and the public to understand whether or not the independent regulatory review processes at these agencies are effective and efficient. I'd like to correct the record. Mr. Sunstein, when he testified, he said he had urged these independent agencies to conduct regulatory review processes, but he did not say that they should submit reports to him, like the agencies under the purview of the executive order. So I was a little confused, Mr. Chairman, when you had said that somehow they should submit reports, because not only are they not required to, but Mr. Sunstein himself does not believe that these agencies are directly subject to the executive order, and that is in order to prevent any president, Democrat or Republican, from overreaching their authority. Now, as we hear from these agencies on their regulatory review efforts, I think we need to keep a few thoughts in mind. First of all, these agencies were created originally as independent entities to insulate them from political influence, and we've given them decision-making flexibilities that other agencies do not have. Secondly, irrespective of the executive order, as I mentioned, there are a number of statutory requirements concerning transparency and efficiency in the regulatory process that already apply to the independent agencies. For example, the Regulatory Flexibility Act requires federal agencies, including independent agencies, to analyze the impact of their rules on small organizations. The Administrative Procedure Act broadly lays out the scheme under which agencies propose and finalize regulations and provides for public participation in the rulemaking process. Finally, it's important to remember that the underlying mission of all the agencies before us today is to ensure the safety and the health of all of our citizens. While we should make sure that the regulations they propose are well crafted and not overly burdensome, we should also acknowledge the importance of the work they do and the regulations that they promulgate. For example, this year, the FCC issued a report and order to adopt a rule requiring mobile providers to enter data roaming arrangements with other providers, allowing consumers to remain connected when they travel outside their provider's coverage area. FTC recently established the Do Not Call registry, which lets consumers choose whether they want to receive calls from telemarketers. This is wildly popular with my constituents, by the way. And every day, FERC acts as a neutral adjudicatory body handling extremely complicated technical issues on the electricity market. But I want to talk just in the last minute that I have about the recent proposals on the other side of the aisle that would undermine the Consumer Product Safety Commission and some of the other good work that they've done. 3 years ago, this committee and this Congress worked hard in a significantly bipartisan manner to put meaningful reforms for consumers into this Consumer Product Safety Improvement Act. This has yielded unbelievable benefits. The CPSC has initiated a wide range of recent efforts to protect children, from mandatory standards to cribs, to the problem of dangerous toys, to banning certain phthalates, and on and on. And this evidence shows that it's beginning to happen. So I think it's important to notice that these reforms were worked out by this committee in one of the last great efforts that was completely bipartisan. We should embrace that. If there are problems with the way the regulations are being promulgated, we need to talk about that. But eliminating these important consumer product safety provisions is simply not an option. Thank you, Mr. Chairman.
Thanks, gentlelady. Gentleman from Nebraska, Ms. Terry is recognized for 3 minutes.
Well, thank you, Mr. Chairman. I appreciate you holding this important regulatory reform hearing. I applauded the President when he issued his executive order creating this cost-benefit analysis and look towards creation of jobs versus elimination of jobs by regulation. And I feel that it's time that the independent agencies adopt this, and that's why I've introduced H.R. 2204, the Employment Act, which will require that all major regulations include a statement of the number of jobs created, lost, or sent overseas because of the new rules and regulations. Under this act, all major federal actions significantly affecting jobs and job opportunities require a rigorous analysis comparable to that given to the environmental impacts. And this legislation would establish a policy that jobs are important, as is public health and the environment. So, and this would be an issue of, you could take into effect the jobs lost by certain American toy companies when we figure out that children don't eat ATVs, but yet banning children ATVs could have an impact on jobs. Now, we've already seen the problems caused by regulators not paying enough attention to the effect their actions have on jobs. In my own district, regulations enacted by the Consumer Product Safety Commission, acting far beyond its authority or intent of this law, what I feel isn't one of the most important ones. It is important, but I think it may be an example of one of the most poorly written bills, too. For example, Wes and Willie's. Shouldn't have used their name, but it's a local small business making children's clothes, some of which they have contracted to have done in China as well as Omaha. Does it really make sense that the same design has to be tested on every size of T-shirt, different color of T-shirts? Does it make sense that they have to add 10 T-shirts together, assuming a child is going to completely eat 10 T-shirts in one setting? None of this really makes sense. So this type of system where it's one size fits all, Mattel versus Wes and Willie's, it really doesn't make a lot of sense. I have found out the irony is that many of these rules don't really protect the consumers, but just make it more difficult to do their job, really putting small businesses in particular on the brink of extinction because of these unnecessary rules and regulations. So I appreciate that hearing, this hearing, so we can protect, and I'll give my time back to the chairman.
I thank the gentleman, and I yield 2 minutes to the gentlelady from Tennessee, Blackburn.
Thank you, Mr. Chairman, and welcome to our witnesses. We appreciate that you're here to talk with us about the President's Executive Order 13563 and It's non-application to the independent agencies. These agencies have refused to voluntarily comply with the order to require justification for the cost and the burdens of their regulations. Some agencies believe that their political ends justify their regulatory means, and that their insulation from the traditional checks and balances is a blank check for them to pursue hyper-activist causes. Bureaucrats bolted a restrictor plate to our economic engine, and they really have flagged private sector job growth to the pits. And now they are resisting voluntary compliance with the Obama order because failing to justify their costly regulations means Congress and the American people are going to raise more questions instead of delegating more power and authority. Now, these agencies don't know how to make the best individual decisions for us. What foods we eat, what toys we buy, what privacy settings we want on our mobile devices, or what light bulbs we prefer to use in our homes. These agencies that use explicit regulatory intimidation and threats of government taking to impose voluntary regulations on job creators aren't even willing to hold themselves to the same standard. They refuse. We need to hold these agencies accountable. Let's ensure greater efforts are taken to balance the economic harms with the agencies that these agencies are causing on our economic growth and jobs. And I yield back.
Gentlelady yields back and recognizes distinguished ranking member, Mr. Waxman, for 5 minutes. Is it 5 minutes, the gentleman?
Yes.
5 minutes for his opening statement.
Thank you very much, Mr. Chairman. This is the fourth hearing this subcommittee has had on the issue of regulations. The others have been on the President's executive order, and the third focused on health regulations that have been recently adopted. Now we're looking at the independent regulatory agencies. The President's executive order applies to those agencies that are under the Office of Management and Budget. They are not independent. The agencies before us are determined by law to be independent. That doesn't mean they don't take into consideration costs and benefits when they issue regulations. They have to have a notice of comment and get full input. I think that what we need to do is to make sure we don't have regulations that are unnecessary, but these hearings that we've had have devolved into forums for questioning health, environment, consumer protection laws that my colleagues on the Republican side of the aisle find objectionable. I was struck by the comments of the last speaker that we don't want these independent agencies. They don't make good decisions. They don't know how to make the best decisions. They are using regulatory intimidations on job creators. I can think of no other expression of hyper view of all of this. We shouldn't have a lopsided focus on the cost with no seeming consideration of the benefits. And we haven't had hearings that have resulted in any substantial legislation or important oversight findings. Now, the four independent agencies have done a lot to make the lives of the American citizens better. The Consumer Product Safety Commission recently launched a new consumer complaint database, which allows parents and concerned consumers to obtain important product safety information which will improve Cpsc's ability to identify trends in product hazards more efficiently. And just this morning, I released the first analysis of the product safety database. We found that in its first 3 months of operation, the database already logged over 1,600 incident reports, including reports of almost 500 injuries or fatalities. And consumers visiting the online database have conducted almost 1.8 million product searches. Now, maybe some of these manufacturers don't want anybody looking over their shoulder, but that's not the job of these agencies to do what the manufacturers want. Their job at the Cpsc is to protect the consumers. Mr. Chairman, I would ask unanimous consent that this report be included as part of the committee record.
Will the gentleman hold? I think we just have a copy of it.
Okay,
so
well, I'll withdraw
just
my
withdraw
request
until
at
we
the moment.
have a chance to look
The
at it.
FCC just proposed rulemaking to require cell phone companies to provide usage alerts that warn consumers of unexpected charges on their bills. Less than 7 months ago, the agency adopted a crucial rule to protect the openness of the Internet. I think these are two very important accomplishments, and Mr. Gett pointed out others. The FTC has recently adopted rules to protect homeowners from scams falsely promising relief from mortgage payments. In the last year alone, the FTC's Bureau of Consumer Protection filed over 60 cases to protect the rights of the consumers. Is this intimidation? It seems to me these agencies are doing their job, and we want to keep them independent from the political pressure that you can see clearly in the comments of members of this committee. FERC protects consumers from price gouging in the electricity and energy markets. These accomplishments are important. They save money for the American public, prevent fraud, improve public safety and public health. They may offend powerful companies that would like to take advantage of consumers and which may have support by some members of Congress in carrying their water. But that's no reason for us to browbeat the agencies. The focus of our oversight should be to help these agencies advance the goal of enhancing the lives of the American family. Our committee is responsible in the area of legislation in some key areas: health care for seniors, setting our nation's energy policy, promoting telecommunications innovation and competitiveness, and ensuring appropriate consumer protections for American families and children. The oversight work of this subcommittee should shed light on how best to legislate in these areas and other important subjects. That is why there are real costs when this committee focuses its time on partisan wheel spinning and messaging. We lose the opportunity to move legislation that will promote jobs, promote economic security, protect health, safety, and welfare of the American public. I hope that we make good use of our time today with the commissioners. I urge the chairman and all members to support their efforts on behalf of the American public. And yield back the balance.
I thank the gentleman, and all opening statements are concluded. I ask unanimous consent that the written opening statement of Mr. Upton and others who wish to provide opening statements for this hearing be made part of the record. Without objection, the documents will be entered into the record. Now it's my opportunity to welcome our distinguished panel. I was trying to realize in my experience in Congress where I have ever seen these many agencies collected together, and I don't think there ever has been, at least in my experience. So it's a very auspicious occasion to have this distinguished group here to meet, and we appreciate you coming. I thought for the members I'd just give you a brief bio of each of the witnesses. Commissioner Robert Adler, Consumer Product Safety Commissioner, is a commissioner at the United States Consumer Product Safety Commission. He was appointed in August 2009. Prior to assuming office, he served as a professor of legal studies at the University of North Carolina at the Luther Hodges Jr. Scholars in Ethics and Law at Chapel Hill's Kennan Flagler Business School. At the University of North Carolina, he served as the Associate Dean of the MBA program and as Associate Dean of the school's Bachelor of Science in Business Administration. Welcome. Commissioner Ann Northup is the Honorable. In fact, she served as the 3rd Congressional District of Kentucky, representing Louisville District in the United States House of Representatives as a Republican from 1997 to 2006, having served with her. Before her tenure in Congress, she served in the Kentucky House of Representatives for 9 years, from 1987 to 1996. On July 30th, 2009, President Obama nominated her to a seat on the Consumer Product Safety Commission and was confirmed by the Senate on August 7th, 2009. Welcome, Ann. Commissioner Robert McDowell was first appointed to a seat on the Federal Communications Commission by President Bush. In 2006, was reappointed to the commission by President Barack Obama in 2009. He brings over 16 years of private sector experience in the telecommunication industry to the commission. Welcome. Chairman John Wellinghoff was named chairman of the Federal Energy Regulatory Commission, FERC, the agency that oversees wholesale electric transaction and interstate electric transmission and gas transportation in the United States by the President Obama, on March 19, 2009, a member of the commission since 2006. The U.S. Senate confirmed him to a full 5-year FERC term in December 2009. He's an energy specialist with more than 34 years' experience in the field. Welcome. Commissioner Philip Muller is currently serving his second term on the commission of FERC, having been nominated by President Obama and sworn in for a term expiring on June 30th, 2015. He was first nominated to FERC by President Bush in 2006 and sworn into office on July 24th, 2006. From 1997 through 2000, he worked in Congress, serving as an energy policy advisor to Senator Slade Gorton, where he worked on electricity policy. And then we have Chairman John Leibowitz from the Federal Trade Commission, served as chairman of this commission since February 2009, was appointed to the FTC as commissioner in the fall of 2004. Before coming to the commission, he had a long career in the public sector, working for the U.S. Senate Judiciary Committee for almost 10 years, and prior to that in the office of Senator Paul Simon. Welcome. And Commissioner William Kovacic served on the Federal Trade Commission since January 2006 and served as chairman from March 2008 to March 2009. He was the FTC's general counsel from 2001 from 2004 and worked for the commission from 1979 until 1983. He has been a professor of law at George Washington University Law School and has also taught law at George Mason University School of Law. Welcome. As you know, the testimony that you're about to give, as subject to Title 18, Section 1001 of the United States Code, when holding an investigative hearing, this committee has a practice of taking testimony under oath. Do you, any of you, have any objection to testifying under oath? No? Okay. The chair then advises you that under the rules of the House and the rules of the committee, you are entitled to be advised by counsel. Do you desire to be advised by counsel during your testimony today? No? If not, then if you please rise. And
Mr. Chairman?
Yes.
I hate to interrupt right now, but the one thing I would ask, at least of one member here, is that pictures are not taken while they're being sworn in. I know this is done, but I just think that it's unfair to the witnesses. I think it sends a message that is not appropriate, and I would ask the camera people not to take a picture of individuals with their right hand raised. I just think it's used too often to send the wrong message to the public. Everyone here is voluntarily participating, and we should not be given a false impression to the public. That is just one member's statement, but I think in the environment of fairness on both sides, I want to raise this issue again and again, and I'm doing that today, and I apologize. Now you.
Well, I thank the chairman, and as you know, he and I are good friends. Unfortunately, I'll have to overrule you. I think the press has a right to take pictures when they want, and I think that's probably what I have seen in my experience being involved with so many oversight investigation hearings as well as others. It's customary to let the press have access, so I'm sorry to have to overrule you. And if all of you would please stand up, raise your right hand. You swear to tell the whole truth and nothing but the truth, so help you God. Thank you. Well, it's my pleasure now to start with the opening statements. And Mr. Adler, we welcome you and look forward to your statement.
Thank you very much. And good morning, Chairman Stearns, Ranking Member DeGette, and the members of the Subcommittee on Oversight and Investigations. Thank you for the opportunity to testify along with my colleague, Ann Northup, on behalf of the Consumer Product Safety Commission. My name is Bob Adler, and I've been a commissioner at the agency since August of 2009. I'm honored to sit in the company of so many of my fellow independent agency commissioners, and I bring you regrets from Chairman Tenenbaum, who is not able to be here today. In order for me to respond to the subcommittee's request for the agency's response to Executive Order 13563 and similar executive orders, I briefly need to review a few critical points about rulemaking at the Cpsc. I do so to make the point that we've undertaken both the promulgation of regulations and their retrospective review in the full spirit of the policies incorporated in the executive orders, despite our being exempt from the orders. So I'd like to make a few observations, and I promise I'll be brief. First, since 1981, the Cpsc has been required under amendments to the Consumer Product Safety Act and to the other acts that it enforces to conduct an exhaustive cost-benefit analysis when we write safety rules. Under these amendments, our cost-benefit approach is as comprehensive, if not more so, as that set forth in any executive order issued by the Office of the President, and I think in the case of any other agency. In fact, over the years, in part because of the detailed and lengthy cost-benefit procedures contained in our laws, the Commission has actually promulgated very few mandatory safety rules under these procedures. Now, I did a count, so I could be off by 1 or 2, but by my count, in 30 years, we've issued a grand total of 9 mandatory safety standards, or about 1 every 3 1/3 years, which has meant we've had to turn to alternative approaches, one of which is working with the voluntary standards sector to promulgate voluntary standards and to upgrade voluntary standards. The other thing that we've done is to work through a very successful corrective action recall program, and I think that's been successful. With respect to regulatory review, you did note the passage of the Regulatory Flexibility Act in 1980. At that time, the Cpsc chose to undertake a retrospective review of every safety rule under its jurisdiction from the very beginning, not just those identified as having a significant impact on a substantial number of small economic entities. Since this review, we've continued for the past 30 years to comply with the requirements for retrospective review of our regulations under the Regulatory Flexibility Act. In addition to conducting a retrospective review of regulations under the RFA, the Cpsc has voluntarily undertaken a comprehensive review of its regulations beginning in 2004 and temporarily suspended in 2007 in a spirit consistent with Executive Order 1356. In fact, in conducting our review, we've committed the agency to using OMB's assessment tool. The only departure from our approach arises because of the enactment of the Consumer Product Safety Improvement Act in 2008. In response to its grave concerns about the need to protect the lives of young children, Congress voted overwhelmingly, and in the House it was a vote of 424 to 1, to set a number of very tight guidelines for the Commission to meet. Our General Counsel did a count of the number of deadlines imposed on us. There were 42 separate deadlines imposed by the Consumer Product Safety Improvement Act. But recognizing the difficulty of meeting these deadlines, Congress streamlined our rulemaking authority when writing these children's safety rules and limited the requirements in the Cpsc for economic analysis of the impact of the rules. The streamlined procedure directed to regulate hazardous children's products such as infant bath seats, baby walkers, and cribs, all of which were associated with an unacceptable number of fatalities and serious injuries, has, I believe, resulted in significantly more expeditious and protective safety standards that should save numerous lives in the coming years, and could not have been accomplished otherwise. I particularly want to note the Commission's new crib standard, which was unanimously approved by all of our commissioners and became effective last Tuesday, June 28th. This standard sets the most stringent safety requirements for cribs in the world and ensures that the place that infants spend the most time and the most time alone will be the safest place in their homes. Having noted that, I hasten to add that even with this new authority under CPSIA, the Commission remains obligated to conduct economic analyses under the Regulatory Flexibility Act, assuring that our most vulnerable small business sector is safeguarded along with safeguarding our most vulnerable young consumers. The Commission is well on its way to meeting the deadlines imposed under the CPSIA. We haven't met all of them, and we're going to miss a few more. But as we wind down the bulk of our CPSIA rulemaking, it's my understanding that Chairman Tenenbaum has directed staff to develop options to restart the retrospective review process. In closing, notwithstanding that independent agencies do not fall under the direct purview of executive orders like 13563, we at CPSC have always tried to implement the wisdom contained in those executive orders and to coordinate our efforts in the spirit of such orders to the best of our ability. Finally, I note that CPSC's jurisdiction is very broad. Roughly speaking, if you walk into a department store, a sporting goods store, a hardware store, a toy store, or you go to a school, that's us. Those products that are in those institutions are the things we regulate. But we're an agency that has barely above 500 people and a budget just about $118 million. In other words, I'm sitting at a table with agencies that are between 2.5 and 3 times our size. But given these limits on our resources, I think we have done a good job in advancing consumer safety, and thank you very much.
Thank you, gentlemen. Ms. Northup, welcome. It's particularly nice to have a former member, so we appreciate your
Chairman Stearns and Ranking Member DeGette, thank you so much for the opportunity to testify in front of you, and I'm delighted to be back on Capitol Hill with you. I have great respect and appreciation for the challenges you face every day and the decisions you make. I do appreciate the opportunity to come and give you some idea of what it looks like from the other side, from a regulatory agency. You just heard an excellent history, a review of the Consumer Product Safety Commission and the past, the way they operated primarily through the development of voluntary guidelines, through risk assessment and intervention when there were real risks based on science, and the ability to intervene when there were dangerous products. However, all of what was said about the reviews and of our regulations and the reasonableness of that changed in 2008 when the Consumer Product Safety Improvement Act went into effect. And in fact, very little of that would be present today. As a matter of fact, we no longer can have the option to consider risk in most of the things we do. We're required to write rules based on numbers that were given to us in the Cpsc. But that hasn't stopped us in the regulatory, through the regulatory process of casting a wider net, including maybe more toys and more children's products or more products than the law requires us to do, to make steps where the testing is more rigid than is required by the law. And so while the law is very difficult, it has been very hard for small businesses in particular to comply with it. We have, at the agency, in my opinion, gone beyond what the law has required us to do. Let me just give you some idea. In the time since the Cpsc passed, we have been involved in about 50 rulemakings, if you include the statements of policies, the notice of requirements, and lab accreditations. And by the way, lab accreditations are huge because anytime we do a notice of requirements for labs to be accredited, within 6 months, every product under that category has to begin sending every component and every part of their product to a lab and for a third-party test and certify based on those tests and label their product to reflect what those certifications are. So in truth, while I appreciated what Representative Waxman said about big companies complaining, it's actually the opposite. Very few of our largest companies complain. Most of them make products in such large numbers that they can spread their cost around. And what we've really done is put out of competition the smaller businesses that made things primarily in this country. Those are the people that we hear from because they cannot spread their cost, these regulations, over so many products. I hear so often people say, "Oh yes, that's the rule that's the law we passed to decrease the number of things coming in from China," or "That's the law we passed to make the big companies comply." But in fact, the effect of the cost of these regulations has been the burden that has put many, many, many small businesses out of business. It's caused them, smaller businesses, to leave, all businesses, to leave the children's product market. We have the public that has fewer choices than they've ever had in the past. And we're told that if our four, by the way, biggest rules are still to come, they're expected to come before December 31st or to take effect by December 31st. I thought I would share with the committee one that I anticipate that we will agree on. Probably the majority, I expect it to be a 3-2 vote, and that is allowing the parts per million of lead in any component of a child's product to reduce to 100 parts per million as of August 15th. This is what our economic team said about this. Economic impacts are likely to occur. They're going to have to use more expensive low-lead materials. They're going to, rather than the non-conforming materials used today, the cost associated with the re-engineering products to make the new materials, the cost to make leaded components that are inaccessible, the increased testing costs, the increased increased consumer prices, the reductions in the types and quantity of the children's products available to consumers, businesses that are exiting the children's product market, manufacturers going out of business, reduction in the utility of products, and the reduction in the durability of products. This is all for this one rule that we're about to allow, or this one step down that we're about to take effect, and it says there's no anticipated benefit in health to children because of this. And so I would just point out to you that 10 out of 40 of the small manufacturers of bicycles left the market with the original step down. We anticipate more will exit the market. And my question, I guess, is what sort of regulation, sort of rationalization can be brought to this process? I have proposed many times ways to, within the limit, the impact of this, and I'm disappointed that we haven't done more of that at the Commission. Thank you.
Commissioner McDowell?
Thank you, Mr. Chairman, and Ranking Member DeGette, and all members of the committee for having me here today. During my 5 years at the FCC, if I can turn on the mic, during my 5 years at the FCC, I've supported policies that promote consumer choice through abundance and competition in lieu of regulation whenever possible. I therefore welcome today's dialogue on regulatory reform. 50 years ago, there were only 463 pages in the FCC's portion of the Code of Federal Regulations, the CFR. During this period, Americans only had a choice of 3 TV networks and 1 phone company. Today, over-the-air TV, cable TV, satellite TV and radio, and the millions of content suppliers on the internet offer consumers with an abundance of choices. In other words, the American communications economy was far less competitive in 1961 than it is today, yet it operated under fewer rules. In contrast, by late 1995, the FCC's portion of the CFR had grown to 2,933 pages, up from 463 34 years earlier. As of the most recent printing of the CFR last October, it contained a mind-numbing 3,695 pages of rules. Even after Congress codified deregulatory mandates with the landmark Telecommunications Act of 1996, the FCC still managed to add hundreds more pages of rules. To put it another way, the FCC's rules, measured in pages, have grown by almost 800% over the course of 50 years, all while the communications marketplace has enjoyed more competition. During this same period of regulatory growth, America's GDP grew by a substantially smaller number, 357%. In short, this is one metric illustrating government growth outpacing economic growth. To be fair, some of those rules were written due to various congressional mandates, and sometimes the FCC does remove regulations on its own accord or forbear from applying various mandates in response to forbearance petitions. But all in all, the FCC's regulatory reach has grown despite congressional attempts to reverse that trend. At the same time, Congress has given the FCC ample authority to deregulate. The legislative intent of key parts of the 1996 Act, such as Sections 10, 11, 202H, and 706, just to name a few, was to reduce the amount of regulation in telecommunications, broadcasting, and information services. For instance, Congress ordered the FCC through Section 10 of the 96 Act to forbear from applying a regulation or statutory provision that is not needed to ensure that telecom carriers' market behavior is reasonable and not necessary for the protection of consumers. Similarly, Section 11 requires the FCC to conduct reviews of telecom rules every 2 years to determine whether any such regulation is no longer in the public interest as the result of meaningful economic competition, and to repeal or modify any regulation it determines to be no longer necessary in the public interest. Removing unneeded rules can liberate capital currently spent on lawyers and filing fees, capital that would be better spent on powerful innovations. Accordingly, it is my hope that the FCC stays faithful to Congress's intent as embodied in Section 11 by promptly initiating a full and thorough review of every FCC rule, not just those that apply to telecom companies, but all rules that apply to any entity regulated by the Commission. The presumption of the FCC's review should be that a rule is not necessarily necessary unless we find compelling evidence to the contrary. The first set of rules I would discard, of course, would be the recently issued Internet Network Management Regulatory Regime, also known as net neutrality. As I have stated many times before, Those rules are unnecessary at best and will deter investment in badly needed next-generation infrastructure at worst. No evidence of systemic market failure exists to justify these overly burdensome regulations. Furthermore, the FCC has too many forms. To give you some examples, there is Form 603, Form 611T, Form 175, Form 601, Form 492, Form 477, Form 323, and Forms 396, 396C, I'm not sure what happened to 396A and B, Form 397 and 398, among many, many others. While a few forms may be necessary, many could be eliminated or simplified. Similar repeal initiatives should be on our plates soon. For example, as I noted in a speech in May, the so-called fairness doctrine is literally still codified in the CFR. The doctrine regulated political speech. Political speech is core protected speech under the First Amendment, and the doctrine is patently unconstitutional, as the FCC found in 1987. Chairman Janikowski recently informed your committee that he supports removing references to the doctrine and its corollaries from the CFR and intends to move forward on this effort in August. I look forward to helping him fulfill that promise. In the same spirit, it is time to eliminate the outdated newspaper broadcast cross-ownership rule in the upcoming review of our media ownership regulations. Evidence suggests that the old cross-ownership ban may have caused the unintended effect of reducing the number of media voices, especially newspapers, in scores of American communities. Overall, however, what is needed is a comprehensive and sustained effort to repeal or, where appropriate, streamline unnecessary, outdated, or harmful FCC rules. All future regulatory proceedings should start with a thorough market analysis that assesses the state of competition in a sober and clear-eyed manner. In the absence of market failure, unnecessary regulations in the name of serving the public interest can have the perverse effect of harming consumers by inhibiting the constructive risk-taking that produces investment, innovation, competition, lower prices, and jobs. In sum, decreasing the burdens of onerous or unnecessary regulations increases investment, spurs innovation, accelerates competition, lowers prices, creates jobs, and serves consumers. I look forward to working with all of you in pursuit of these goals. Thank you, Mr. Chairman.
Thanks, gentlemen. Welcome the Chairman, Wellinghoff, for your opening statement.
Thank you, Chairman Stearns, Ranking Member DeJet, and members of the subcommittee. I want to thank you all for having us here today, and my colleague, Commissioner Muller, to discuss our views on regulatory reform and independent agencies. We've submitted a full testimony here that I'd like to have entered into the record, and I'll summarize my testimony. The Commission continually seeks to streamline its regulations in order to foster competitive markets and facilitate enhanced competition to minimize consumer costs. In implementing the statutory authority provided by Congress, I'm committed to assisting consumers in obtaining reliable, efficient, and sustainable energy services at a reasonable cost through appropriate regulatory and market means. Fulfilling this mission involves pursuing two primary goals: ensuring that rates, terms, and conditions are just and reasonable and not unduly discriminatory or preferential, and promoting the development of safe, reliable, and efficient infrastructure that serves the public interest. The Commission has taken and continues to take a number of steps to make certain that its regulations meet the fundamental objectives set forth by Congress without imposing undue burdens on regulated entities or unnecessary costs on those entities or their customers. For example, the Commission has taken several steps to remove barriers to entry of new businesses and technologies which facilitate competitive markets and can lower consumer costs. The Commission also seeks out ways to help entities, particularly small ones, navigate the federal regulatory process. The Commission has also recently reduced burdens on applicants, speeding up processes of filings, and improved public access to documents. In sum, I support the goals of Executive Order 13563. I've directed the Commission staff to conduct a review of the Commission's regulations with the goals of the Executive Order in mind. This direction is consistent with the Commission's practice of engaging in constant self-review to avoid red tape or unnecessary regulation that would impose undue burdens on the energy industry and its consumers. Thank you, and I look forward to answering any questions.
Thank you, gentlemen. Mr. Commissioner Muller, welcome.
Thank you, Mr. Chairman, Ranking Member DeGette, members of the committee. Appreciate the chance to be before you today to talk about these important issues. I welcome your oversight, and I will summarize my written comments. But with a brief history, I guess, of how our regulation has evolved at the Commission, and then give you 3 examples where I think we kind of struggle with balancing the need to ensure that our services are provided safely at fair and just rates, but also making sure that we're protecting and not unduly burdening the entities that we regulate. The Federal Power Commission, our predecessor, really came into its own after the passage of the 1935 Federal Power Act and the 1938 Natural Gas Act. And as regulators then, the Commission was highly regulating these entities because they were monopoly providers of services that were deemed essential. But over the decades, and particularly in the last 25 years, regulation has evolved so that more competitive forces can provide consumers with, frankly, lower prices at better service. These came through 2 landmark orders on the natural gas side, 436 and 636, which restructured the pipelines. And then on the electric side, orders 888 and order 2000 that set up regional markets and allowed for open access of the transmission systems. Again, these have had great benefits for consumers, but our responsibilities as regulators in monitoring these markets has increased substantially since then. 3 areas where we particularly spend time, the first of which I'll say is the reliability area of assuring the reliability of the bulk power system. Now, the origins of this issue came from the 1965 Northeast blackout, and a voluntary set of regulations came about after that. But as time went on, particularly in the late 90s, it was clear that a mandatory system was going to be necessary, some kind of a cop on the interstate electric highway. And although there was legislation in the late 90s, eventually it took the 2003 blackout and the 2005 Energy Policy Act before you as Congress directed us to create a national electric reliability organization with 8 regional entities. And in the meantime, we've adopted 101 national standards, 11 regional standards, and we've had a very active enforcement process on those standards. In fact, we've had 7,000 violations to date since they became mandatory in June of 2007. And frankly, we're struggling with it. Our role, the role of NERC, the role of the regional entities, because we have a bit of a backlog on these violations. They're up to about 3,200. I think the good news, though, is that through NERC, or through our direction to NERC, they are working to make sure that there is it's a better streamlined process so that we can eliminate the backlog and essentially share the best practices amongst the entities we regulate on the bulk power system. A second area is related to that, and that is with our new powers of enforcement that you gave us in the 2005 Energy Act, partly emanating from the Western crisis in 2000 and 2001. You gave us the kind of major league enforcement authority that few agencies have. We can fine entities up to $1 million per day per violation. And initially, when we put out some of our rulings with some significant fines, there was some criticism from the industry that we lacked transparency in the process and lacked priorities. And I'm happy to say that our Office of Enforcement, under the urging of several of us on the Commission, has opened up that system so that we're a much more transparent system now. We adopted annual priorities in terms of enforcement, adopted guidelines based on the U.S. Sentencing Commission, and essentially have processes and policies in place that allow anyone under investigation to know at certain times that they are and give them the certain rights that other agencies give them. So we're making progress there. The third area I'd note, because I come from the Pacific Northwest, is the hydropower system. We regulate 2,500 hydropower dams throughout the nation, and some have complained that that process of licensing, or more often relicensing, is both costly and time-consuming. And that much is true. But I don't think much of that can be put on FERC. I think actually the laws itself that govern the process of relicensing are worth looking at if this is something that inspires you, because we actually, I think, do a good job under the current system of setting timetables, but often the resource agencies don't have any consequence to missing the timetables involved. In the meantime, though, I think we've tried as an agency to develop small hydropower systems through MOUs with various states that are interested. We've tried to open up the process to stakeholders and developers that are interested in small hydropower development. and we've come up with a pilot licensing process for the new hydrokinetic technologies of in-stream power, ocean power, and tidal power, again, in a way, through our regulations to try and encourage an industry to move forward. And finally, I'll send a compliment to our colleagues at the Federal Trade Commission. They've been active in some of our rulemakings, and their perspectives are always very valuable. Thank you for the opportunity again to testify, and I look forward to answering any questions.
Thank you, gentlemen, and Chairman Leibowitz, welcome.
Thank you, Chairman Stearns, Ranking Member DeGette, Mr. Bart, and Dr. Burgess, Mr. Terry, members of the subcommittee. Let me thank you for the opportunity to appear here today with my friend and my colleague, Bill Kovacic, to discuss the FTC's longstanding regulatory review program. It has been, and it is a bipartisan priority for us, as well as our plans for ensuring that this program continues to protect American consumers while minimizing burdens on American businesses. Today, the FTC is announcing additional measures to strengthen our regulatory review process, including an expedited schedule for reviewing rules and guides to meet the demands of the marketplace, a new streamlined form for pre-merger filings, a new page on our website to provide greater transparency and public participation in reviews, and a sort of review of the reviews. That is, we're asking stakeholders how we can make our review process even better. In that same spirit, we're also seeking to identify acts of Congress that appear to be of little value but that impose burdens on businesses, particularly small businesses, and the Commission. So let me give you a brief overview of the FTC before Commissioner Kovacic describes the history and nature of FTC regulatory reviews. After he's finished, I'll tell you a little more about what the Commission is doing today to enhance and improve our approach to regulations. Simply put, we are building on our longstanding regulatory house-cleaning efforts over the years, under which we've eliminated outdated rules from the Mad Men era, including those addressing extension ladders, fiberglass curtains, and frosted cocktail glasses. That's true. As you know, the Federal Trade Commission is the only federal agency with both consumer protection and competition jurisdiction in broad sectors of the economy, and our work touches the life of virtually every American. We're primarily a law enforcement agency, but we perform our mission using other tools as well, including rulemakings from time to time, either when Congress asks us or when additional clarity is needed in the marketplace. Most of our rules, by the way, are a result of directives from Congress because you've recognized that they would be valuable to consumers and businesses alike by protecting all of us from unfair and deceptive acts or practices and by leveling the playing field so that legitimate businesses aren't at a competitive disadvantage from the bottom feeders who don't always play fair. And with that, I'd like to turn it over to Commissioner Kovacic.
Mr. Chairman.
Mr. Kovacic, go ahead. Just for members' information, the two of the gentlemen from the Federal Trade Commission are going to split their 10 minutes, so they'll be going back and forth, as I understand. Welcome.
Thank you, Mr. Chairman, Madam Ranking Member, and your colleagues for the opportunity to speak here today. Although the executive order that we've been focusing on doesn't bind independent agencies, the FTC does endorse its goals, and in particular, we endorse the intuition that changing market conditions dictate ongoing efforts to determine whether existing rules have become outdated, unduly burdensome, or simply ineffective. To ensure that our work meets this objective, since 1992, we've had a voluntary program to review our rules and guides. We examine each regulation and rule in a 10-year cycle. Each year, we publish a schedule of review, and we begin the examination of each rule or guide by publishing a Federal Register notice, and this notice seeks comment on the continuing need for the regulation or the guide and an examination of its costs and benefits to consumers and businesses. We also ask whether consequent economic developments call for changes in the rule or its outright abolition. We also consider whether the measure conflicts with other intervening state, local, or national legal commands. We use these comments and we use the results of workshops that we conduct from time to time to decide whether there's a continuing need for the regulatory command or guideline and how needless burdens could be avoided. And if adjustments are warranted, we start proceedings to modify or repeal the rule or guide. As John mentioned, through this process, we've repealed 37 rules and guides. We haven't repealed one outright since 2004. I think we did look at the most serious cases first, but we have undertaken modifications with respect to others since that time. We now have 12 reviews in place. In one proceeding, we're considering amendments to the labeling requirements for the alternative fuels and alternative fueled vehicles. And here we're assessing how to eliminate the need for firms to apply redundant labels that are mandated by different agencies. In another instance, we've accelerated the review of our Hart-Scott-Rodino mechanism for mandating the notification and reporting of mergers, and we intend to initiate reviews of 11 more rules or guides by the year's end. Comments provided in this process, I think, overwhelmingly show business support for not only the mechanism we've used, but for the rules and guides themselves. And our guidelines in particular stand out as means to reduce business burdens by clarifying what we regard to be the line that separates appropriate from inappropriate behavior. And in doing so, we think we've significantly reduced the cost of complying with what you know to be the exceedingly broad general mandates that appear in our statutes. My colleague will now explain recent measures that we've taken to enhance this review process, and I look forward to your questions and comments later. Thank you.
Thank you. As Commissioner Kovacic has explained, we have long had a program for reviewing our guides and our regulations. You noted, Chairman Stearns, in your opening statement, the importance of taking costs and benefits into account, and we do that. It's critically important to us. All of our work, including the guides, is done publicly with input from stakeholders. But earlier this year, we began examining what more we could do to improve these rules and really relieve undue burdens on industry. So as part of this effort, and very much in the spirit of the President's executive order, here is what we are doing. First, as Commissioner Kovacic noted, we are undertaking a review of 23 rules and guides. That's more than a third of all the rules we administer, rules and guides we administer. As announced in our Federal Register notice today, 6 of the rules under review have been accelerated to take into account for rapid changes in the marketplace. Congresswoman DeGette, you mentioned the do not call rule, and we recently strengthened the do not call rule, the telemarketing sales rule, which do not call is part of. It has 200 million, actually now more than 200 million registered phone numbers, and Dave Barry has called it the most effective government program since the Elvis stamp. Second, our Federal Register notice asks for the public to comment on the FTC's 20-year program of reviewing its rules. Businesses have generally been, as Commissioner Kovacic noted, supportive of our regulatory reviews, but we nevertheless ask a number of questions. For example, how often should the Commission review rules and guides? How can we modify programs to make them even more responsive to the needs of consumers and businesses? Third, the FTC's new regulatory reform website just went live today. Because not everyone reads the Federal Register, although I know many of you do, it serves to provide, and many of us do, it serves to provide greater transparency for members of the public to understand our regulatory review efforts and allows them to more easily comment on our ongoing rule reviews as well as on the FTC's process to review its rules. It also contains links to the 37 rules the Commission has eliminated over the years, as well as easy links to other resources like the new 10-year review schedule and the streamlined HSR Hart-Scott-Rodino pre-merger form. Fourth, Commission staff are seeking to identify statutes that might impose undue burdens on businesses or on the Commission. Although a law's goals may be laudable, some statutes passed by Congress, as we know, can detract from other beneficial work. And I think Commissioner Muller sort of alluded to this with respect to licensing issues. So one example is the FACT Act, which was passed in 2003, Fair and Accurate Credit Transactions Act, and it came out of the Financial Services Committee. And it required the FTC to conduct 30 separate rulemakings, studies, and reports. 30. Some of those obligations, of course, made sense. But at one point, around 2005, and this was shortly after I came to the Commission, about a third to half of our financial practices staff, and these are the folks who go after mortgage fraud, were actually spending time writing reports because they were obligated, and we do what Congress tells us to do. Now, we have been writing reports since 1914. We are very good at it, but in fact, our staff should have been spending more time going after the bad guys who were preying on American homeowners. So, consistent with the goal of reducing unnecessary burdens, Commission staff is now working to identify reports required by statute, and I think statutes themselves that divert businesses or commission resources from more pressing work. And the staff has identified sort of two such reports, at least preliminarily. So year after year, the mandated ethanol industry report has shown that there is almost no concentration in the ethanol fuel market. The report doesn't appear to provide significant value to the public, but it does impose burdens on small businesses because they have to respond to inquiries from the FTC. And so our staff is proposing that the report be eliminated, or at the very least, that the frequency would be reduced to every 3 years. Additionally, while the FTC, the DOJ, and the Department of Education are very involved in fighting scholarship scams, and for the FTC's part, we compile complaints. The annual report about scholarship scams, the annual report that the three agencies must jointly produce each year on the topic, which is required by statute, doesn't appear to FTC staff to advance any real or significant goals. So, Mr. Chairman, through these four initiatives, we are working to improve the FTC's review program. We will do our best going forward and working with this committee to ensure that all of our regulations protect American consumers while minimizing burdens on businesses. Thank you. Of course, we're happy to answer questions.
Mr. Kovacic, do you have anything briefly you'd want to add, since Chairman Leibowitz had most of the time?
No, I don't. Thank you.
Okay. All right. With that, I'll start with opening questions. I think before I start, I'd like to put on the record Mr. Castine's memorandum of February 2nd, 2011. Without objection, so ordered. And I understand the ranking gentlelady has a document, evaluation of the Consumer Product Safety Database, that she would like to put in.
That's correct.
Without objection, so ordered. Chairman Leibowitz, before I start my question, I'm just, I think myself and staff are a little struck that you have voluntarily stepped up to the plate and sort of follow the spirit of this Castine-Sten letter that right there. And I think it's interesting when you look at the letter I just put on the record. He said, in particular, such agencies, talking about the independent agencies, are encouraged to consider undertaking retrospective analysis of the existing rules. You have stepped up to the plate to do it. Not all the independent agencies have done it. You've actually identified some areas that you think you have to do where you don't think you should be doing it. So I guess the question for members of Congress is, what would you like us to do to help you?
Well, I think having oversight hearings like this is
Brings it to bear.
enormously useful. It
Right.
sort of shines a public light on regulations that do work, because of course regulations are very important, and ones that need to be modified. You know, look, we're a very bipartisan, consensus-driven agency. We work together. We try to do regulatory reviews because we know they're really, really
Well,
important.
you've identified some things that I think you'd like some legislation to say.
And
you
yes,
have to
and
do.
we've identified
We'll
some-
follow up on that.
That would be terrific, Mr. Chairman.
Commissioner McDowell, I couldn't help but take your comments sober and clear manner when you talked about over 50 years regulations have gone up 800%. Is that true? That's 16% a year in the law of 72. That means every 4.5 years these regulations are doubling. That is really staggering to think that that's occurring. Is that an accurate explanation of what you said, that regulation could possibly be doubling every 4.5 years based upon 800% increase for 50 years?
That would appear to be the case, yes.
Okay. Let me move based upon what I just put a letter in from Cass Sunstein where he said these independent agencies should step up and volunteer. That was the spirit of what he's talking about. Obviously, President Obama has indicated he wants that done, and he didn't include the independent agencies, but I'd like, if you would, just to answer some questions, yes or no, just for the limited amount of time I have. So Commissioner Adler and Northup, yes or no, did the CPSC submit a regulatory review plan to OMB? Just yes or no.
No.
Okay.
No, it didn't.
Okay. Yes or no, has the CPS publicly committed to conduct a review of all existing regulations in accordance with the executive order? Yes or no?
As far as I'm concerned, yes.
No, I've not been informed that we're doing
Okay.
anything, having any review.
Okay. Mr. Adler, if you answer yes, as you did, why hasn't there been a notice so that Commissioner Northup would know about it if you answered yes?
Well, first of all, with respect to submitting a formal plan to Cass Sunstein, he's actually a hero of mine as a former academic, but in order to preserve independence...
Have you said you have issued a public notice or not?
What I said was we had begun a retrospective review beginning in 2004.
But you haven't issued a public notice
that
yet.
was temporarily suspended in 2007.
Okay.
And as soon as Chairman Tenenbaum gets back, I anticipate we will
Okay.
resume that
So you
process.
personally believe the CPSC should conduct a review?
Oh, yes, sir.
Okay. CPS used to conduct regulatory reviews, but has stopped in recent years. Is that a fair statement?
They stopped in 2007 under then Acting Chairman Nord, and I believe it was because of passage of the Consumer Product Safety Improvement Act and a just competition for resources within a very tiny agency.
Okay. Commissioner McDowell, do you believe the reviews the FCC conducts under the Telecommunications Act take the place of the kind of look back the President and this committee has simply asked for?
No.
Okay. You also state in your testimony that net neutrality is the first rule you would discard upon the agency review of its regulation. Is that true?
Yes.
I agree with you. Chairman Janikowski hails the net neutrality rulemaking proceedings as a test case for openness. However, I believe there were some bad precedents set in this proceeding. Commissioner McDowell, do you believe you were able to review the record in the net neutrality docket, or were there items placed late into the docket that made it very difficult to review before the vote?
There were about 3,000 pages of documentation placed into the record in the final 2 or 3 days or 4 days.
And you had no opportunity to review those?
Well, there was opportunity, but there wasn't enough time.
Not enough time, okay. As a commissioner, when was the first time you saw the net neutrality order that you voted against on December 21st, 2010, and was it the same rules proposed in October 2009?
There were several drafts, of course the first in October of '09, but we got the final draft about a quarter to midnight the night before the vote.
Okay. I understand although the agency passed its net neutrality rules in December, the docket to reclassify broadband services under Title II remains open. I think this is surprising, as Chairman Janikowski has made efforts to close other dockets open at the FCC. Do you believe this docket should be closed?
Yes.
Are you aware of any reason why this docket remains open?
Only speculation. I have no firsthand knowledge.
Chairman Wellinghoff, in your testimony you say you support the goals of the executive order and have directed Commission staff to conduct a review of existing regulations with the goals of the executive order in mind. Why didn't you submit a regulatory review plan to OMB?
Because I believe that we weren't subject to the executive order under OMB.
Notwithstanding what Cass Sunstein had sort of directly, the spirit of the law was for you to comply?
I believe, in fact, we are complying with the spirit of the law by directing the regulatory review that I've directed staff to do.
Have you submitted a notice for public comment on this review?
My general counsel's indicated that's not necessary to staff review.
Well, let me ask you personally, do you believe FERC should conduct a retrospective review in the spirit of the executive order?
Yes, we are doing that. I've directed my staff to do that.
Okay. My time's expired.
Thank you, Mr. Chairman. Mr. Chairman, my recollection of what Cass Sunstein said is that the independent agencies should comply with the spirit of the law, not the specific legal requirements. And I guess I'll ask you, Chairman Leibowitz, since your agency is supposed to be the paragon of virtue today, have you submitted a plan to OMB? Has your agency submitted a plan to OMB?
We have not submitted a plan to OMB.
And that's because you're not legally required to,
And
right?
that's because we are not legally required to, although, as you know...
That doesn't mean you're not doing regulatory reform.
No. I
correct?
think as everyone knows, we're doing a lot of regulatory
Okay, and Commissioner Adler, also your agency, although it hasn't submitted a plan to OMB, you're doing regulatory reform too.
That is correct.
Thank you. Now, Chairman Leibowitz, I wanted, something you said was very interesting to me. You talked about how a lot of the regulations that you do is a result of statutes passed by Congress directing you to do regulations, correct?
Sure. That's correct.
And you gave several examples of that, right?
Yes.
Now, Commissioner Northup, you talked about a lot of the regulations that the Cpsc is promulgating as a result of the statute that Congress passed, correct? Like the lead standards and other regulations. So, Mr. Chairman, one thing I'm concerned about is you can't really talk about regulatory reform in a vacuum without looking at the statutes that Congress has passed that ask these agencies. And so I think I think there's two levels here. There's the regulations themselves, which may be overburdensome, but there's also statutes that I think we should look at. And I know, Chairman Leibowitz, you had actually come up with a list of some statutes that you think could be streamlined so that the agencies, whether they're the independent agencies or not, could also streamline their regulations, correct?
That is correct.
Would you be willing to submit a copy of those statutes to this committee so that we could then look at those statutes within the purview of this committee and think about ways to fix them so that we can reduce the burden of regulations?
Yeah, it sounds like very much a bipartisan effort on this subcommittee, and we'd be glad to do that.
Okay. For the rest of the commissioners who are here, I would just ask for a yes or no answer. Would you be willing to also submit a similar list of statutes that your agency deals with that you think could be streamlined so the regulatory process could be streamlined? Commissioner Adler?
Yes.
Commissioner Northup?
I have.
Oh, you have? Great. I'd love to get a copy of that.
Yes.
Commissioner McDowell?
Yes.
Chairman?
Yes.
Commissioner? And Commissioner Kovacic?
My list is the same as John's.
Okay, great. This is a good effort down here at the end of this table. And I wanted to ask you, Commissioner McDowell, because you had listed off a number of numbers of regulations. I don't think that you think that, first of all, are those regulations that you listed, I don't know them by heart, are they all duplicative or unnecessary regulations, the ones you listed?
Are you talking about the number of pages I cited?
No, you listed some different sections. You just threw out a whole bunch of regulations.
The sections I cited were statutory sections that gave us the power to deregulate on our own. Then I also listed
No, but
forms.
you said there's a whole, the form.
The forms?
Now, just because there's a form doesn't mean that it's per se unnecessary, correct?
No, and I didn't imply
So the numbers of the forms that you listed, are those particular forms unnecessary in your view?
Not all of them necessarily.
Okay, so
That's what I said in my testimony.
You were just that was just kind of a figure of speech that you were talking about.
Well,
There's a lot of forms, right?
I think that my testimony speaks for itself. It's a lot of forms that they can
Well,
be
here's my
simplified or
question
eliminated.
to you. Have you compiled a list of regulations for your agency that you think are duplicative or overly burdensome?
Yes, ma'am. It's in my testimony.
Oh, okay. That's the comprehensive list. And has everybody else?
Not the complete list, but there's.
Could you get us your complete list?
give you
Because
more
that
if
would
you'd
be
like.
really helpful.
Sure.
You know, we're along with our brand new member from Colorado, Mr. Gardner, my neighbor to the north, and others. We're trying to develop bipartisan legislation. And to be honest, as you see from these folks down here, regulatory reform is not a partisan issue. I mean, nobody wants to have overly burdensome regulations. And so I guess what I would ask everybody here from all of these agencies, as well as a list of statutes that you think lead to overly burdensome regulations, if you can give us a list of regulations at your agencies that you think are overly burdensome, that would be helpful too. Commissioner Adler, would you be willing to do that?
I'm speaking only for myself, but for myself, yes.
Okay, Commissioner Northup, I believe you've probably already done it.
I have. It's part of my testimony, but I've also previously sent to the Hill a list of changes.
If you could get that to our staff too, that'd be great. And Commissioner McDowell,
Absolutely.
I assume, Mr. Chairman?
Yes.
And Commissioner Muller?
Yes.
And then,
Yeah, we certainly will, although we have eliminated a lot of regulations.
Okay.
We do ongoing regulatory reviews pretty rigorously.
okay, thank you very much.
Gentleman from Texas, Mr. Barton's recognized for 5 minutes.
Well, thank you. I would stipulate that all the individuals before us are paragons of virtue today because they're subject to the Energy and Commerce Committee, and that definition makes you a paragon. I think we need to repeat, this is kind of a hearing that's unusual in that this executive order that we're asking you folks to comment on explicitly excludes you. And as we all know in Washington, not too many commissioners and chairmen voluntarily comply with things that they don't have to. So those of us that have been around a little bit understand that. So my first question is, what should this committee do in the absence of statutory language that would force compliance with something similar to the executive order? Should we pass some sort of a statutory requirement that y'all do similar things that the President says in his executive order, or should we let the sleeping dog lie? let's try Chairman Wellinghoff. He doesn't come before us too often, so.
Thank you, Mr. Barton. I don't have any specific recommendation for you, sir. I think, in fact, as I've indicated in my testimony, we are going to comply with the spirit of it and, in fact, have a staff review. And I think our agency, certainly as a economic regulatory agency, in each and every regulation that we institute, do, in fact, take into account whether rates are just and reasonable and services are, and we also provide the industry with an opportunity to fully comment on those regulations and determine ultimately whether regulations are burdensome based upon those comments and information that we gather. So I don't have any specific recommendation for you.
Mr. Leibowitz?
I would say this. You know, we comply with the spirit of the executive order. I think it's a terrific executive order. We go beyond it because I think only 4 of our rules would be sort of within reg flex, and we do reg reviews of all of our rules and all of our guides. But I also think it's important to preserve the independence of agencies too. And as you can see, you know, agencies provide, by having members not of the President's party, agencies, as a sort of institutionalized matter, provide checks and balances, and they're independent voices. And so I understand what you're saying, because I think you believe that the executive order has a lot of good things in it, and we agree.
Republicans think what the President says he's doing. We're not sure he's doing it, but what he says he wants to do, we think is a good thing. And so you folks are, you know, say the right words, you're going to comply with the spirit, and you agree in general, but the truth is you're not going to do anything unless you absolutely have to.
Well,
so the question is, should I get with Ms. DeGette and Mr. Stearns and put together a bipartisan bill that would make it a requirement?
Well, let me defer to Commissioner Kovacic, because I know he wants to add something here.
Congressman Barton, I'd like to quarrel with your suggestion that we only do what the gun at the head compels us to do. I was a junior case handler at the FTC for the first time in 1979, and I think it's been in the DNA of the agency internally, partly because of our structure, partly because we have a large team of economists to do this kind of introspective work as long as I've known the agency. And I'd emphasize that I think what would be very constructive would be 2 things. First is for us to have perhaps a more frequent conversation in settings like this with your staff about what we do. In 2008, 2009, we did a comprehensive self-study of our agency. We benchmarked ourselves with 40 of our counterparts overseas. We talked extensively with our counterparts at federal, state government, and we did a substantial publicly available assessment of how we're doing. I think it would be helpful on one front to have a more extensive continuing conversation with the committee about the measures we do take that aren't obliged. And the second is to go back to something that several of you have mentioned.
You're going to have to be, because I've got 20 seconds and I've got one more question. So
the other thing is to think more in the design of legislation itself about what burdens it will impose.
I want to ask Commissioner McDowell. I mean, I can't let him sit here and not ask him some question. The pending regulation regulating the internet and, under Title II is still pending at the FCC. Do you have any information for us what Chairman Janikowski intends to do with that? Is he going to withdraw it or push forward with it? What's your view on that?
So just to be clear, the open proceeding to regulate the internet under Title II, I don't have any information as to whether or not he's going to withdraw it or what the reasoning might be for keeping it open.
Don't you think he should withdraw it?
I do.
Okay, that's the right answer. Thank you, Mr. Chairman.
Thank you, gentlemen. I think the next speaker on this side is Mr. Green. Recognized for 5 minutes.
Thank you, Mr. Chairman. First, I want to take the opportunity to thank all our commissioners for being here. Those of us who've been on this committee a number of years realize it, and even welcome back our colleague from Kentucky. What you do on every day is very important in ensuring the safety and health of our citizens, particularly consumer protection, but everything. FERC, obviously from Texas, FERC is very important to what we do in the FCC, and of course FTC. Mr. Leibowitz, in your testimony, you discussed the Children's Online Privacy Protection Rule, regulation your agency promulgated that helps protect privacy of children online. Can you please tell us more about this rule, and does it ensure that children are protected while using the Internet?
Well, it was a bipartisan piece of legislation passed out of this committee, but we also understand that the Internet has changed and technology has changed the way children use the Internet dramatically in the last few years, and that's why we actually moved up our regulatory review of COPPA by 5 years. And so we are working with stakeholders. We put out a sort of notice of inquiry, and we will have proposed COPPA improvements. Draft legislation, we always put out, draft rule, we put that out, we take comments again, hopefully within the next few weeks by the end of the summer.
Well, and I know for all the agencies, it's just an example, there's a lot of concern about agency regulation, but so much of what you do is in response to legislation.
Sure.
Whether it's new legislation or previous legislation that may have been amended. And this is a good example of a rule that, frankly, as a father or a grandfather now, I can't possibly monitor what my grandchildren may be doing on the Internet, but we do need to have some protection from an entity other than just a family.
Right, and the whole notion of COPPA, which is that if you're 12 years old or younger, you shouldn't be able to give consent to have your personal information go to companies on the Internet. You need to have parental consent, is a really good one, and that's sort of at the bedrock of COPPA, the law you passed.
Some of us might move that age a little higher, but
I
appreciate it.
Some of us might encourage you to do that.
And beyond issuing standards that require safety such as that, you've done children's cribs, consumer product safety works on manufacturers to organize recalls and remove dangerous products from the market. Ms. Adler, a recall authority has the potential to save lives, doesn't it?
It certainly does, sir, and I believe we've saved many lives.
And other agencies have tools to help consumers, too. For example, the FTC has taken steps against consumer fraud and deceptive practices through its enforcement powers.
All the time.
Ms. Leibowitz, in your understanding at the FY 2010, your agency initiated 66 court cases to protect the rights of consumers. How valuable is that enforcement action?
Well, we think they're critically, we are principally an enforcement agency. We do rules mostly when you tell us to, but what we really do on both the antitrust and the consumer protection side is go to court to stop unfair, deceptive acts or practices and to stop people who engage in unfair methods of competition. And we have brought a variety of cases protecting privacy, stopping mortgage scams. That's what we do.
The lawsuits you file can have a real impact on individual lives. Is that correct?
Yes, and I mean, often in getting redress if we win a case or if we settle one for injured victims, yes.
Well, so there is a positive byproduct of agencies issuing regulations and enforcing regulations that are based on what Congress passes and the President signs.
Absolutely.
Okay. Mr. McDowell, I was pleased that the chairman of the FCC announced that the Commission would comply with the President's executive order on regulatory review. It's important that that review is comprehensive and as possible. I'm looking forward to seeing the streamlining of the FCC, which I'm sure as commissioners would love to have. Given the constant change and the growing competition in the communications market, do you agree that the FCC should be diligent in reviewing and potentially eliminating regulations that no longer protect the public interest?
Absolutely, in a comprehensive way.
The biennial review requirement is the Commission's major tool to accomplish this. Is this correct?
It is, but only for telecom companies, not for media companies or information service providers, et cetera.
Over the past 10 years, the Commission has complied with its statutory duty to prepare and submit a biennial review.
Yes, sir.
Okay. Do you believe the biennial review requirement should be amended to include other entities?
I do.
Okay. And would you submit your recommendations for the record?
Yes, sir, and it's in my testimony, but I'll reiterate it too.
Okay, appreciate it. Mr. Chairman, I'll yield back my time.
Gentleman yields back his time, and the gentleman from Nebraska is recognized for 5 minutes.
Thank you, Mr. Chairman. Let me first start by thanking John Leibowitz. First of all, I like the little play between the two of you because it kind of signals that you work with both sides and work together. And Mr. Kovacic, in the way that you've answered questions, you're telegraphing that or telling us that you two actually work together. And I really appreciate that. I think that's the way America expects our agencies to work. So I want to thank you for that. And John, you're doing a good job. So I like that you're actually.
Is this a setup? Because
no, there's no comma but coming here. I like that you're already attacking the issue of finding the regulations that are not very useful anymore and don't serve the purpose. So good job. That's exactly what my bill that's in a different committee wants every agency, independent agency to do, and it's not, it's to provide the flexibility. And Ann, I want to talk to you, I'm sorry. Commissioner Northup.
Anna's fine.
And, because we can sit here and say, good job on cribs, but it's amazing to me that we're sitting here talking about bicycles and ATVs and large cars and trucks that, you know, 6 and 7, 8-year-olds play with, but don't eat, but yet we're regulating them. So you have to admit, Mr. Adler, there's some absurdity to the law. Do you agree with the rules and regulations?
I think that Congress basically got the law right. And by the way, what you're talking about is a mandate that Congress imposed, not that the Commission imposed. But there are always some portions of the law that need to be reexamined. And the issue you raised with bicycles and ATVs is one of those that we are actually taking a look at.
And in regard to the absurdity of Congress's mandate, and by the way, I list this as one of those votes that I thought if I had to take back, we should have really fought harder on this one to make it a better law. So, Ann, do you have specific requests for us of where we should change the
Well, let me just say, if I had been there, I wasn't, but I can imagine that I would have voted for the law. I certainly would expect I would have. When I was being confirmed by the Senate, I read the law. It seemed like such a good law. I was supportive. So many of the senators at the confirmation hearing said, we want you to use all the flexibility we gave you to rationalize this law. We believe that bicycles and ATVs and scooters, I mean, it goes way beyond those two. Carving them out may make some people happy, but like you say, trucks kids play with, the axles in those trucks, if they bend, what good are they? And but the problem is, when we've tried to find flexibility, there just hasn't been 3 out of 5 votes for that. So it's going to take a change in the law. The discouraging part is that even the commissioners can't seem to agree how sweeping a change they would support. But we desperately need.
Well, do you have flexibility on, for example, third-party testing? I think there was an incident when this bill was being developed by a toy manufacturer that manufactured in China that perhaps there was accusations that their data in-house was not correct. So if you're a large international company mandating third-party testing when you found out your in-house testing was inaccurate, but do it on a 10-person company in Omaha, Nebraska on T-shirts where on every size and every color doesn't make sense to me. Do you have the flexibility with third party?
No, we don't have that flexibility.
Is that an area that we should look at?
It is an area. In fact, today, there are vast new ways to enforce the law. We track things coming in from overseas, tools that we didn't have in 2008. And I would give the Commission the ability, the flexibility to require third-party testing where they think there is risk and they think it'll be effective to enforce it. It's one of the proposals I've made. It would make a huge difference in the cost of this because, as you say, every small business is telling us when they have to third-party test every single component individually for lead, when they have to then do random
or phthalates,
when they have to do phthalates, when they have to do it to the toy standard, it's extremely expensive.
Well, and one quick point on that. Do you guys try and obtain data, for example, on when the third-party testers are telling a small company that prints motorcycles on T-shirts that asking that they test the cumulative effects of 10 T-shirts of the same color and size Do you produce one piece of evidence that a child has eaten 10 T-shirts?
The problem here is that if there is, say, a dot of blue paint on that, they need enough blue paint to test to have a quantity of blue paint. I will tell you, I have pushed for a component part testing, allowing somebody to, and I think we're going to pass this, and this is the flexibility that I think is probably the most flexible regulation we had, where you can take your blue paint and test it, and then you can put it on every T-shirt, and you don't have to tear up the T-shirt. But when you talk about bikes, for example, that have 141 parts to them, and every part, every time you change the shipment of spokes, the shipment of pedals, you have to have a new test for that. Then you have to change the label so it reflects the component test that was used. It's very complicated.
Time has expired, and Jen Nikowski, young lady, is recognized for 5 minutes.
Thank you. You know, I think we all here agree that it's important for regulatory agencies to be efficient and mindful of the impact of regulations on businesses, and I think we all agree. I helped negotiate this bill, very proud of the legislation. But Henry Waxman introduced legislation that would deal with some of the unintended consequences. I think maybe we as a committee ought to take another look at that legislation, and I know the commission would be willing, as I understand it. Is that not true, Mr. Adler? And on behalf of Ms. Tenenbaum and Ms. Northup, I think we ought to look at that. But let me just say, to go back to risk-based assessment, that's what we had before. And I think that what we have found is that why we regulate, and that's because time and time again, industry has shown that they aren't going to police themselves, and that we need to do it. And one of the issues is the industry standard for cribs, and we had a press conference with the Attorney General in Illinois on June 28th when the crib standard went into effect, and I congratulate all of you on that. Although I have to say, I was disappointed to see the press release that went out that you know, we didn't give people enough time, when of course you had said earlier that you wished it had gone into effect the next day, so that parents could be sure when we put our kids to bed alone or grandchildren that they're going to be safe. So let me ask you, Mr. Adler, do you consider the crib standard to be an example of a victory for the Consumer Protection Improvement Act?
I think it's one of the finest things that's been done under the Consumer Product Safety Improvement Act. It's taking children who are our most vulnerable, involuntary risk takers, who are put in cribs that have to be the safest place in the home because they're there for long periods of time with no supervision, and it is saying that we have the most stringent safety standard in the world. I think it's really a magnificent achievement, and I commend the Congress for directing us to
and in fact, in your regulation, you did give some places that might have cribs some time to comply. Is that not true?
We did, and I'm delighted to respond to the issue that Commissioner Northup and I disagree on with respect to the independent retailers. I think that we had a group that said we need more time, but we had another group that said, please, please, please do not give more time. We have complying cribs, and we're prepared to sell them right now.
Right. I wanted to mention on the database, I have an op-ed from a gentleman in New Jersey whose daughter was injured by a crib in 2007. He called the manufacturer and asked if they had any other complaints about the crib, and was told no, there weren't any, but actually found out that there were 84 reports to similar problems. Fortunately, his daughter was not hurt very bad. So, Mr. Adler, the public information database was created by the CPSIA because previously manufacturers would not, and the CPSC could not, share life-saving information with consumers. Is that correct?
That is correct. I think the database is one of the finest pieces of the Consumer Product Safety Improvement Act.
So do you think that it actually is serving the function of making consumers more aware?
It is, and I might just quickly point out that it's modeled after a similar database at the National Highway Traffic Safety Administration. Ours actually has more due process rights for manufacturers than they do at NHTSA, and I think it's a very balanced piece that provides the proper attention to disclosure to protect consumers with the rights of manufacturers to make sure that the information is correct.
Do you think that Congress should force the Consumer Product Safety Commission to do a full cost-benefit analysis every time it takes steps to protect children from harmful products, no matter how dangerous those products are?
I actually think Congress got it right. Congress didn't say regulate with no attention to the economic impact. Congress said that when we regulate with respect to children, that we need to follow the dictates of the Regulatory Flexibility Act. And one of the things I like about that is it is focused on vulnerable small business. That is the group that we are supposed to make specific economic findings with respect to when we're trying to protect our most vulnerable consumers.
And I think I'll yield back the 2 seconds I have. Thank you, Mr. Chairman.
Thank the gentlelady. Gentleman from Texas, Dr. Burgess, recognized for 5 minutes.
Thank you, Mr. Chairman, and Commissioner Northup. It's good to see you here. It's amazing you got confirmed by the Senate, so congratulations on that. Quite an accomplishment.
We were.
Would you, and I apologize for being late, we had a health subcommittee hearing going on simultaneously. Can you give us an idea of the scope of the effect on the retail industry on this crib ban that has now gone into effect? I realize that the other commissioner said a cost-benefit analysis is not necessary, but still, there's got to have been an impact.
Let me just say, first of all, the regulatory flex analysis that we do is it's like checking a box. Sometimes it's a paragraph, sometimes it's a page. It says there's small businesses are going to be affected. We're going to put some out of business, but we go right ahead and regulate. There's no requirement that it be cost effective. What happened with the crib standard is that we issued it and we considered at the request of manufacturers how long it would take for them to get the new qualifying cribs tested, third-party tested, and into the market. 6 months was decided. We didn't really think about retailers. There was one sentence in our rule that said, we think 6 months is enough for retailers too. Unfortunately, it took longer to get them developed. It took longer to get them tested. And by the time they got them to the retail stores, some of them, orders that they had placed last November, arrived a week before the new standard took effect. They were not third-party tested, and so they were junk to them. How many? Well, we know that one group of retailers that did a survey had 17,000 of them. We know that we called 5, not our biggest stores, but 5 major retailers. They had 100,000 as of the 1st of June. That comes to about $32 million worth of materials that will have to be thrown away if they're not, and these are not drop side cribs. These are not even cribs that aren't almost identical to the standard. They haven't been third-party tested or certified, but the new crib standard that went in 2009 was the basis of our crib standard. And let me just say, if those are unsafe, then why would we have allowed daycare centers, the motel, hotel industry, leasers 2 years before they had to place them? It's because we did not believe they were unsafe.
That's a valid question. You know, in the winter of 2008, it was kind of a bleak time up here on the Hill, and with no thought to my personal safety, I took a trip to the Cpsc and looked at the testing facility. It's remarkable in that it is very Spartan. There's certainly no.
We have a new one now.
Oh, you do have a new one?
Yes,
This was
we
the
just
old,
moved 3 weeks ago.
old missile base, as I recall when I went out there, and I was struck. The folks there were working diligently, and they were quite inventive and innovative, and I actually took a great deal of confidence away from that. But at the same time, boy, I'll never forget sitting in that press conference that the people on the youth motorcycle thing put together a couple of years ago. Beautiful little blonde-haired boy, about 10 years old, in full motocross regalia, standing at the microphone and said, "Mr. Congressman, if you'll let me ride my bike, I promise I won't eat the battery when I'm finished." And you know, that's the level of absurdity to which we've sunk.
This testimony today has been fascinating. Hearing the agency talk about the DNA of the CPSC is really fabulous. But that has all changed because of the CPSIA and the rulemaking that we have done in compliance with levels and requirements that are unrelated to risk. For years, this agency was risk-based. It worked with the Voluntary Standards Committee, which is very important because products emerge, they evolve, and these voluntary standards keep up with these evolutions. Anytime we didn't think they were strong enough, we had the right to intervene, and we did, as my colleague pointed out.
Let me just briefly, I do need to ask our friends from the Federal Trade Commission a question on the, familiar with the ACO, if you read the Federal Register, you may be aware that there was a healthcare law signed last year that's caused some of us some grief. And then this new Accountable Care Organization reg came through. Did you guys participate in the writing of that regulation?
Well, we participated. It's principally from CMS, as you know, and we.
Well, what I know is when we had the briefing, we had one guy from CMS and two guys from the Federal Trade Commission.
One from the Federal Trade Commission, one from the Department of Justice, because we wrote it with the Department of Justice, or maybe two from the Federal Trade Commission and one from the Department of Justice. So we did the antitrust component, and their draft guides. We're taking comments. We did a workshop. And can I just say one other thing, and I'll turn it back over to you. I mean, we believe that competition is critically important in healthcare, not regulation. And so what we're trying to do with the ACO implementation, and we'll see, you know, ACOs are a brave new world and very uncertain, but what we're trying to do is make sure that competition principles remain.
Look, you give the antitrust exemption to Major League Baseball and National Football League, but here's the deal. The 21st century healthcare model, and this was started in the previous administration with Secretary Leavitt, has been continued with Don Berwick at CMS, and now we've got an ACO rule that doesn't work in actuality. The rule is you took something that was working in practice and rendered it invaluable in theory, and that's the problem that I see with what you've done.
We have certainly, one of the reasons why we put out draft guidance, and again, we have a small component of it, it's only the competition portion. One of the reasons why we put out draft guidance and why we are meeting feverishly with all stakeholders is we want to make sure that, you know, to the extent that there's an uptake on ACOs, and the notion you pick up vertical efficiencies by putting together, as you know, different doctor practices, lab testing facilities, and a hospital is not a bad one. We want to make sure that you don't have one dominant provider, so that you know, it soaks up all the efficiencies. And we also
what about McCarran-Ferguson? I mean, you give a dominant provider status to insurance companies.
The gentleman has expired.
We'll just point out we cannot review the insurance industry. We're exempted from that. But yes, I hear what you're saying. I don't think we're in disagreement. We're going to try to make it work better.
The gentlelady is Ms. Christensen is recognized for 5 minutes.
Thank you, Mr. Chairman, and I want to also add my thanks to all of the commissioners for being here. And as I listen to the testimony, it seems that all of the independent agencies that you represent have been undergoing some regulatory reform, and even though you're not under the executive order, that you've really gone beyond what you had been doing to keep in spirit with that regulatory, with the executive order, and I commend you for that. I sat on the Small Business Committee for about 10 years, and each of you are governed by the Regulatory Flexibility Act. So you're required to have the impact of your regulations on small business reviewed. I was going to ask Commissioner Northup, my classmate, about the effectiveness, but you've already kind of said that it's not effective. Is it the experience of the other commissioners that the Regulatory Flexibility Act does not do enough to protect our small businesses?
I don't agree with my colleague about that. I think that especially with respect to the impact of the Regulatory Flexibility Act on our agency, I think it's been a very good provision. I was just reviewing Section 604 of the Regulatory Flexibility Act, and to me, it is a smaller but focused cost-benefit analysis, and it's something I think the Commission has done very conscientiously.
Did I misinterpret what you said?
No, it's often just a paragraph in a long rule. And even if we find that it will impact small businesses, it's not even, it doesn't require us to decide it's still worth going forward to make any changes to our rules. It's had no impact on the rules that one or two maybe, but very few that I can remember ever.
Does anyone else have that experience with RFA?
I find it to be toothless, and if you look at it from an appellate perspective, the appellate courts agree there's really nothing the courts can do to make agencies change their rules based on the RFA.
That would be very disappointing, but it seems as though most agencies have had, most of the commissions have had good experience with the act.
I think, Madam, that it has some limited effect in focusing our attention on things that are important, but I think there are a number of other things we've done that have tended to be more significant, that have come from within, and we'd be glad to share those with you at your pleasure.
Thank you. And what I've been hearing is that most of the commissions have gone beyond what really has been required, and I appreciate that. Commissioner McDowell, on July 20th, you wrote a letter to Chairman Janikowski offering several recommendations on how the FCC should be reformed. You suggested reforming it to be more transparent, efficient, accountable, and fiscally responsible. And from prior testimony to date, we've learned that Chairman Janikowski has proactively implemented some of those changes to facilitate your suggested reforms. Through these reforms, the FCC has improved external communications by creating a more user-friendly website, which include providing live streams of all public workshops and meetings. Do you think this new website has enhanced public participation and access to FCC activities?
Well, the FCC's website right now is a bit controversial. It depends on which segment of the audience that uses it you ask.
You don't think that it's enhanced the public participation?
Certainly, in general, I think Chairman Janikowski has taken some discrete steps on an ad hoc basis, but I'd like to see more comprehensive reform done.
The FCC has also made effort to collect broader input from the public and industry, which included having more than 85 staff-led public forums and reinvigorating external advisory committees. Do you think these efforts have allowed for an increase in public participation?
Absolutely.
In fact, you've had several workshops on the National Broadband Plan to discuss potential reforms to the Universal Service Fund. Do you think that those workshops have been helpful?
They have, certainly.
Okay, and although the FCC is not subject to President Obama's executive order on regulatory reform, the FCC initiated their own look-back process, which is also included in their statute. According to a letter Chairman Janikowski sent to Chairman Upton and Chairman Walden, this effort has resulted in the agencies eliminating and or revising 49 regulations and identifying more than 20 sets of unnecessary data collection requirements for possible elimination. Is that correct?
I don't know. I haven't seen the list of the 49 or the 20, so I'm not quite
reasonable
sure.
In the
and I don't know if some are just mainly data collection. I think the proceeding, as I understand, under Section 11 that was initiated really was just focused primarily on data collection, although it has general language in there. But the thrust of it was data collection and not just a comprehensive review of all of our rules that apply to all the entities regulated by the Commission.
Our information is that 49 regulations and identifying maybe 20 sets of unnecessary data. So it seems to me that the FCC's current leadership has been really successful in implementing new ideas on how to improve current regulations, and I look forward to hearing more from the Commission and their continued focus on ensuring the public participation and open exchange of ideas that improve the work of our government. And my time is up. I yield
Thank the
back.
gentlelady, and the gentleman from California, Mr. Bilbrey, is recognized for 5 minutes.
Thank you. Mr. Adler, you were bringing up this issue of trying to make sure that we have the safest cribs in the world, as we say. What percentage of the cribs that are on the market in the United States have elevated platforms or are made of a hard material, wood, plastic, steel?
I don't know the answer to that. I'd be delighted to.
Would it be fair to say the overwhelming majority of them have elevated platforms or are made of hard material?
I think that makes sense.
And then wouldn't you agree that any elevated platform or material made hard that when you have a child you have a potential for injury because of dropping off of an elevated platform, or injury because some activity that may end up meaning impact with the hard material. So there is a risk in both of those design features?
That's an excellent point, and the Commission's standard is addressed to what we consider the unreasonable risks, but I don't think we could make that a fatality-free zone under all circumstances.
Okay, and that's the point, is what's a reasonable level? You know, you could sit there and say that because we do not require all cribs to be on the ground, we do not require all cribs to be made of inflated material or soft material, it is not the safest it could be. It is reasonableness, and I think that's a determining factor. Wouldn't you agree?
I would absolutely agree with that, but what we have done is make the cribs that are produced in the United States the safest within the types of fatalities that we think that
Okay.
it's reasonable to
I just
expect.
think that and I appreciate that, making sure that, you know, we make these claims and these statements as elected officials or as public officials, but it's reasonableness that really is the determining factor, and that is where the judgment issue has to come down. Let's talk reasonableness. Mr. McDowell, you recently discovered that the so-called fairness doctrine was still on your books almost a quarter of a century after it was abandoned. Do you think it's reasonable that a federal agency has basically misinformation, if not, you know, some people may say the lingering lie of the fairness doctrine on your books? Do you think it's reasonable that almost a quarter century after a regulation isn't there, it still is being stated as being part of the process?
I don't think it's reasonable that the language remains on the books, if that's your question.
And what are we doing to make sure that there's not, this mistake isn't throughout your, in your regulatory guidelines? So where the public and the business community can read something and find out, is it the gospel or isn't it?
Exactly. If the commission has opted not to enforce a rule, the rule should disappear from the books.
Okay, let's get down to the fact that the FCC has taken nearly 12 months. And I'll say this, I spent decades in regulatory agencies, so I understand how tough it is when you're in a regulatory agency of trying to take the theory of legislation and make it a practical application. But when you've got decision making that is delayed for over 12 months, you know, and there's nothing on the books to require us to, or require you to make a decision in what's a reasonable time period. Don't you think, is there anything to make you make a decision in less than 12 months?
Certainly statutory language helps. There's nothing like the force and effect of law, but even that sometimes is not observed. For instance, the video competition report we're required to produce every year. The last time I think I voted on one was in 2007.
Okay, so in other words, we need to basically tighten it up, but also have some enforcement on that tightening. I'll just tell you, somebody that built the light rail system in San Diego, we abandoned any federal funding just so we could avoid the regulatory oversight. And we built that system under budget and on time because we didn't take federal funding. And I think that's one of the things we don't talk enough about. People want transit, they want this, they want that. Sometimes the most important component to get the public the services that you claim you care about is getting the federal regulatory agencies out of the way so you can get the job done. And I guess that's what I'd just like to state down the line. Mr. Muller, you were talking about hydroelectric. When you're reviewing hydroelectric and the relicensing, are you required to consider the no project option and the environmental damage done if you don't approve it? Things like climate change, emissions, pollution, and that kind of thing. Are you required to basically take a look at this and understand that if you do not approve it, it will have an adverse impact because the alternative energy capabilities or generation is going to cause pollution where the hydroelectric is not?
Well, typically I think of the no action alternative as truly no action as opposed to perhaps modifying or taking out of dam, and then the consequence being that it would be a result of more generation that would be less environmentally friendly than hydro. But typically I think it essentially doesn't get to that. It's a long settlement process where that.
But you don't have a specific requirement that you have to consider offsets for shutting down a plant?
Not that I'm aware of.
Well, that's one of those things that I think that we need to talk about, Mr. Chairman, more, is that, you know, when you don't approve a road improvement, you should have to offset the pollution caused by the congestion rather than always we look at all of the emissions that happen for construction. But the no project option and the environmental and economic and social impact of that need to be considered. But the environmental impact is one that I find a real hypocrisy, that you want to have offsets for the emissions caused for building the project, but nobody who's stopping the project has to account for the environmental pollution caused by not finishing the project. Now I yield back, Mr. Chairman.
Thanks, gentlemen. Gentleman from Louisiana, Mr. Scalise, is recognized for 5 minutes.
Thank you, Mr. Chairman. I appreciate you holding this hearing. I appreciate all of the commissioners who have come here to participate and talk about the costs of regulations, especially how it impacts people. And you know, when you look at a lot of the intent and what's usually said about regulations that come out, they all sound really good. And you know, and usually the name of a bill, you can tell how bad it is by how good the name sounds. It's usually an inverse proportion. And so as I talk to people, and you know, our economy is still very sluggish right now. And of course, in many cases, when you talk to small business owners, when you talk to American job creators, as many of us do, the first thing they'll tell you that's the biggest impediment to job creation in America are federal regulations. You know, all of the other things that get in their way, they can manage. It seems like the federal regulations have become the biggest burden to creating jobs in America today. And so when you look at some of these regulations, you definitely want to look and see what is the real impact. Are they even achieving some of the results that they were intended to? And in many cases, you find out they're not. And then you look at some of these agencies, and we've had a number of hearings, and I appreciate the chairman having the hearings that we've had, going through various agencies, even looking at the president's executive order. And we've seen, and it's been pointed out even by some of the people implementing it, the shortcomings of the president's executive order, how it doesn't really get at the cost of regulation. And I read, there was a report that was recently done by the Small Business Administration. It's titled, "The Impact of Regulatory Costs on Small Firms." And this really looked at how it impacts our small businesses, the people that actually create the bulk of the jobs in our economy. And you know, I guess it's not surprising for those of us that have been in some of these hearings, but they talk about the cost of federal regulations as a whole to small businesses is over $1.7 trillion. And how does that break down? I broke it down per family. Over $15,000 per family is the cost to small businesses of these regulations. And so when you look at the regulations and you look at the impact and how it's not only affecting jobs, and it's a major impactor that's costing us jobs, but it also costs every American family over $15,000. You say, well, where's the bang for the buck? And I want to ask Commissioner Northup, you touched on this in your opening testimony. You talked about some of the things you've seen, and you've seen businesses go under, actually go bankrupt because of some of these regulations. And in many cases, had actually no health impact. You know, bills that were sold as, and regulations that were sold as helping the health of children had actually nothing to do with health. And it just had to do with some kind of radical policy somebody had that didn't help anybody's health. It just made a company go bankrupt. Can you expand upon some of the things you've seen in terms of how these regulations not only impact the businesses that you've talked about, but also how in many cases there's not even a relationship between health and
Well, I'll give you two quickly. One of them is in the bill that you passed, you had exclusions for with the lead limit for electrical products, and we have a whole cutout for that. You had an exclusion for inaccessible parts, and we have addressed that. You also had an exclusion for lead where not any lead could be absorbed. I assume you meant for some things to be included in that. Perhaps screws, nuts, and bolts that are holding a crib together. Maybe the handlebars of a bike, because lead in the handlebars, if you suck on it, unlike paint, it is trapped in that metal. You can't suck out the lead. But our agency, even though I proposed a de minimis standard where if you rub the handlebars and less than a molecule could be gotten off that, it couldn't possibly change your lead content. That absorbability exclusion that you wrote in the bill, I intended you meant for it to apply to something. And the rest of the commissioners decided no, and so basically they have found that even though you wrote in the non-absorbability exclusion, that it applies to nothing, that there's not one material it applies to. If we had nuts, screws, bolts, things that can't be swallowed, things that have small amounts in them that are in lead and trapped in steel, that those things would have been excluded from this law. It would have made a huge difference.
And let me ask you, and I'm running out of time, I want to ask just by show of hands, how many people have actually read this report that came out just a few months ago on the impact to small businesses of the regulations? Can I get a show of hands? Not one person on the panel read this. I think it should be required reading for all regulators, but if I can ask unanimous consent to submit this into the record. Final question, if I can ask Commissioner
Before we
McDowell.
put it, the minority would like to look at it,
Sure.
have it, and
Well, I'll be happy
so,
to hand that over. It was a report that was published in September of 2010. It cites a number of sources, but goes into very good detail on sector breakdowns, also differential between large businesses and small, how they differentially fall higher even on our small businesses. Commissioner McDowell, can you give an assessment on the things that the FCC did to take into consideration? It was looking at both net neutrality and data roaming rules. Did they look into and do proper market analysis, in your opinion, to look at the impact, how that would be on our job creators?
There was no proper market analysis, no finding of market power. In fact, the order, the net neutrality order, says as much, that there was no market analysis conducted.
And see, that's the problem with a lot of these regulations that come down. They have dramatic impacts on job creators, and they cost us jobs, run jobs to other countries, and yet it just seems like the regulators kind of go into their own shell and are oblivious to the actual impact on our economy. So hopefully we can shift that course, and I appreciate the chairman for having this hearing and more like it to get our economy back on track. Thanks. I yield back.
and the gentleman, the minority has looked at this, so by unanimous consent, this will be made part of the record. So I thank you for bringing this. The gentlelady from Tennessee, Ms. Blackburn, is recognized for 5 minutes.
Thank you all for your patience in being here. Commissioner McDowell, I want to stay with you on that net neutrality order. No market analysis done, no look ahead at what the cost-benefit analysis was going to be. If there had been that analysis done, do you believe the Commission would have gone ahead and issued that order?
I think so. I think that whole proceeding was outcome-based, outcome-driven.
Okay. Chairman Leibowitz, I want to come to you. I'm concerned about with the FTC's food guidelines, food marketing guidelines. I have 2 grandchildren. They're age 3 and age 2. And so things of this nature really I pay a lot of attention to. You know, you think about the unintended consequences that are going to come forward with this, and I think that what you may see is that an unintended consequence could be seen as hampering free speech, harming our economy, and not having a significant reduction in childhood obesity. And one of the things that I have found recently is that the food currently sold through the WIC program, which is designed by USDA experts to provide a healthy diet for young children, could no longer be marketed under this proposal. So you claim these proposed food marketing restrictions are voluntary, but aren't these government standards going to form the basis for NGO attacks? And then also talk about what you think. I think that you could see there should be concern about shareholder actions. So if you will address that quickly, please.
No. Thank you, Congresswoman. Well, first, as you know, this was an obligated requirement. We're not the only agency. We do the marketing side. We don't do the science side. You know, that's the Agriculture Department, the CDC, and the FDA. But it was a Sam Brownback, Tom Harkin obligation in our appropriations bill. We're obligated to do what Congress tells us to do. It's voluntary. So in that sense, there's no enforcement mechanism. We're taking comments from stakeholders, and let me just say, and you recognize, as we all do, there's an obesity crisis, and there are twice as many obese children as there were a generation ago. But speaking only for myself, you know, I try to take a sort of pragmatic approach here. If my kids eat Special K with yogurt in the morning, which actually wouldn't quite meet the nutrition guidelines, I'm pretty happy. Because you know what? I think that's like, you know, better than what else they might eat or better than not eating anything at all. So my understanding is that within the next week, first of all, we'll be getting comments, and we'll be reviewing those comments very seriously from stakeholders. But within the next week, my understanding is that the food marketing companies are going to come up with some proposed standardized or uniform guidelines. If they come up with guidelines that are good, and I think they will, then we ought to take that into account going forward, members of the working group, and we will.
Let me shift gears with you. I want to go to the privacy issues that are out there. And we know that the internet online advertising is really an economic engine in this country, and the industry is beginning to voluntarily enter into some self-regulatory structures when it comes to privacy. Do you believe the FTC should impose a top-down technology mandate on the internet governing the privacy issue?
The last thing we want to do, no.
Okay. Thank you for that. I appreciate that. I think that just as I said with Chairman McDowell, if you were to look at the net neutrality issue, if there had been a robust review, a cost-benefit analysis, I think that it would have been determined that the net neutrality order, especially paragraph 84, was going to be detrimental to our economy, and I think that a heavy hand on the privacy issue would likewise. I've got less than a minute. I want to ask each of you, just a show of hands, how many of you have read executive order that we are discussing and have been through the process of reviewing that? Show of hands. Okay, so all of you have. All right. How many of you disagree with any part of that order? Is there any part of that order that you have disagreement with? Yes, sir. Go ahead.
I don't think, I think a number of the provisions aren't very well specified. I think it could have benefited from a much fuller discussion about how it intended specific trade-offs that are implicit in the order were to be made. There's been subsequent guidance, subsequent commentary. It's a nice start.
Okay. Anyone else? Commissioner?
I would agree. I think it could be broader and more comprehensive and more aggressive.
Okay. Any other addition to that? No, thank you all for your patience. I know you know we've had juggling hearings this morning, and we appreciate it. Yield back.
Gentlelady's time has expired. The gentleman from Virginia, Mr. Griffith, recognized for 5 minutes.
Thank you, Mr. Chairman. Put my eyeglasses on so I can see everybody better. Commissioner McDowell, it's nice for me to be able to say that in a formal setting and in my new role. When I look at the FCC's merger review process under Republican and Democrat administrations, I see a process that appears to be broken. XM and Sirius merger took way too long. The Comcast-NBC merger took way too long. There's simply too much discretion for the Commission to halt the timeline for the review, the transfer of control of licenses in an expeditious manner. Is there something we can do to provide applicants with certainty regarding the timing of the FCC review process?
And Congressman Griffith, it feels good to say that as well. My first time saying that publicly, so congratulations. Yes, you know, the FCC has a 180-day shot clock that is honored more in the breach than in the rule to get mergers done. I read yesterday also that the Assistant Attorney General for Antitrust, Christine Varney, is stepping down, and there's a big merger, the AT&T-Mobile merger, that needs a fair, thorough, and expeditious review, and I would hope that her stepping down doesn't delay that. I think we could get that done by the end of the year in a fair, thorough manner. But I've been in a dialogue with Chairman Janikowski about making sure that we move as quickly as we can on our merger review process. I think there are a lot of problems with how the Commission, under both Republicans and Democrats, have conducted themselves in terms of taking too long or imposing conditions that have absolutely nothing to do with the substance of the merger itself. So Congress could look at that. There could be a statutory provision, certainly, but the best thing to do would be for the FCC to honor its own 180-day shot clock.
So, Congressman, may I just add something?
Yes, please.
We do, from time to time, work with the FCC on merger reviews, and I think from our perspective, you don't deserve a particular outcome, but you do deserve a sort of a speedy resolution. Sometimes it takes a little longer with documents, but that's what you deserve. So I think that's a reasonable point.
And I agree.
And I think most of us would agree with that as well. Commissioner Northup, do you think the Congressman Waxman's proposed legislation will actually ease any burdens under the Consumer Product Safety Improvement Act?
No, I don't think it goes nearly far enough. And in fact, you know, he has proposed previously a functional purpose exemption, which I have to say is like picking winners and losers. If you think a part, first of all, it says it can't be harmful to children, and then it says if it serves a function, for example, in a bicycle and is necessary, then we can exempt it. Well, what if it doesn't harm a child? Why do we have to then exempt it in part by part? It means that big companies that have lots of product or big expensive products can afford to get a functional exemption because it's a very complicated petition you would have to file with us. They can afford to file the petition, all the supporting work and everything, and then we can exempt them. But for small needs, for these same exact materials that do not harm a child, I don't think that you know, they probably would be able to afford either the weight for us to act on it or the cost to put the petition together. So that in particular to me is, you know, is not a good way to go about easing this. Making the absorbability a useful exception would make a huge difference.
And did you want to add on to that?
Well, I wanted to disagree.
Well, let me, and somebody else may give you time to do that, but I've got one more thing I want to say, and if I could take back my time because I'm running out of time. I did hear from several of you as I was listening to this testimony that you all, at least a couple of you, made mention that perhaps the legislation created more of the problem than, I think both you and you, Commissioner Northup, the legislation created more of the problem than the agency created, and that we should be careful when we craft legislation that may be costing jobs as well as the regulations costing jobs that are ultimately awarded. And that while in some cases it may be an agency that's pushing the envelope, in some cases it's just the agency following exactly what Congress told them to do. And I do appreciate that. I yield back my time.
Gentleman yields back the balance of his time. The gentleman from Colorado, Mr. Gardner, is recognized for 5 minutes.
Thank you, Mr. Chairman, and thank you for your time and testimony today. Chairman Wellinghoff, in developing energy policies, such as policies to support the integration of renewables, demand response, or the deployment of smart grid technologies, does FERC evaluate the impact that increased energy price, evaluate the impact that increased energy prices resulting from the implementation of these policies will have on jobs?
The policies that we implement aren't directed to specific technologies, but rather directed to the integration of all technologies into a competitive marketplace. We believe, and I think my colleague, Commissioner Muller, I think would agree, that we believe that competition is good for consumers. And so to the extent that we can maximize competition, we can increase the types of resources that are available in the market, whether they be coal or nuclear or natural gas or solar, geothermal, hydroelectric, or any of these resources, and also to the extent that we can do things like incorporate in demand response and energy efficiency, which are usually the lowest cost resources. The whole mix of those resources in a competitive environment, allowed to compete fairly in that competitive environment, will in fact produce the lowest cost for consumers.
So do you do an analysis that these policies, the impact will have on they will have on jobs?
We don't do a specific impact on.
So you don't do a jobs analysis then?
We don't do a specific analysis.
A specific analysis on jobs. You do not
no.
do a specific analysis on jobs.
We don't, but we do believe that.
So in terms of,
excuse me, if I could finish, we do believe.
Well, actually, reclaiming my time in terms of the executive order. So you do not believe that the executive order, which I think you said you believe in the spirit of, you do not believe that it requires you to look at jobs. I understand that you're exempted from it, but you believe, you said you want to follow the spirit of it. Do you think you ought to be concerned about jobs and looking at the job impact?
I think we are always concerned about jobs to the extent that we can drive down prices in a competitive atmosphere and allow for the economy to have access to low-cost power. To the extent that we can provide low-cost competitive power within the economy, we are going to create jobs and we're going to maintain jobs in this economy.
But you don't do an analysis to know that or not?
my basic economics is what I know of basic economics tells me that if we can lower costs for electricity, we're going to have the ability to increase jobs.
Would you commit today
now,
to start beginning a jobs analysis when you make decisions?
I certainly have no problem looking at jobs. I believe, for example,
But shouldn't we
your
do more than
colleague
that? I mean,
from
shouldn't that
Louisiana,
be our
your colleague
intent?
from Louisiana, for example, was talking about this issue with respect to jobs. And regarding that, Entergy, which is one of the utilities in Louisiana, has chosen to join a competitive market, MISO. An analysis was done that showed by joining that competitive market, something over $700 million could be saved. I think there's a lot of money if you can take that money and save it for Louisiana consumers and others throughout the region. It wasn't just Louisiana, but spread out the region. That additional money in the pockets of consumers is going to help them create jobs and invest back in the economy in ways that more jobs will be created. So I think that's a very valid example of the types of things that FERC is doing through the regulations and the competitive structures that we're putting in place to ensure that, in fact, we can create more jobs in the economy.
and then, so what you're telling the committee then, and I believe what you just said, though, when it comes to developing energy policies, like integration of renewables, demand response, or the deployment of smart grid technologies, then you are saying today that you will do a jobs analysis on these decisions.
I'm saying that to the extent that it's possible to do so, we certainly will, in fact, look at the impact on jobs.
Well, I think we ought to be looking at the impact on jobs no matter what we do, so that we have an idea of what's happening.
I absolutely agree.
And so, Commissioner Muller, do you care to comment on this?
I generally want to associate my remarks with the chairman because we're believers in competitive wholesale markets and that those ultimately are what benefit consumers the most and allow more resources. I think we should always be cognizant of the employment impact we have on rising energy prices because it can be substantial.
Thank you, Commissioner Muller, and I see my time has expired, and I yield back.
I thank the gentleman for his questions. I think we're completed with our first round. I think the chairman, chair lady, and I, the ranking member, and I have talked that we're going to ask a few more questions and then wrap up. I don't think there's ever, in my experience, has ever been such a distinguished group of people that could make an impact on deregulation in America as you folks today. So we're here with a certain humility and asking you, what is the best way for us to move forward? I mean, as Mr. Scalise pointed out with that Small Business Administration report, had every U.S. household paid an equal share of the federal regulatory burden, each household would pay $15,586. That was in 2008. And when you compare that with what we spent for health care costs in 2008, the federal regulatory burden exceeded by 50% the private spending on health care, which equaled $10,500. So it's within your power to deregulate and to get rid of burdensome regulations, which would spur the economy. So we're not talking about something insignificant. So I guess the larger question is, we passed in 1980 the Regulatory Flexibility Act. Obviously, that's not applicable today, and it's not working. So the question is for you, is a sort of a wrap-up understanding. The President reached out with his executive order, did not apply to the independent agencies in some of your opinions. We think Cass Sunstein's letter did imply, but we don't seem to have you jumping to the forefront to try and deregulate. Should Congress, through either statutes or legislation, provide either more flexibility to you, or should we update the Regulatory Flexibility Act of 1980? So we're reaching out for you to tell us, one, should we do some of the things I mentioned, and secondly, would you be willing to help us in terms of providing us documentation on what we should do? And I'll just start with my left, Commissioner Adler.
Mr. Chairman, the devil's always in the details. I would be delighted to look at anything you drafted and to respond to it.
So you think that we should take the Regulatory Flexibility Act of 1980 and update it in Congress?
Actually, I'm probably a bigger fan of the Regulatory Flexibility Act than some folks here. As I read it, I think it's a fairly useful tool, especially in terms of what we do when we're trying to regulate, and we're looking in particular the impact on small business. That is actually something that both Commissioner Northup and I agree on, is that we do have to worry about the impact on small business.
Okay, Commissioner Northup.
Yes, but unfortunately, it has no teeth in it. If you, no matter what the regulatory analysis is, if you decide in our agency that you should go ahead and regulate, it's almost, it has no impact in what we do. So unless we're required to justify the cost with the benefit, adding that to it, I think that would be an important improvement, but other than that, it's a box we check, and it doesn't have an effect.
Just for your information, I checked the Consumer Product Safety Act. Everybody in Congress voted for it under the Bush administration except one. That was Ron Paul. So you probably would have been like most.
I'm sure I would have. And, you know, like I said, when I first read it before my confirmation, I was really very excited about it.
Sure. Commissioner McDowell.
I think a statutory action is the best way to sort of cut through this Gordian knot of regulation and statutory provisions that have built up over the years. And so I would be happy to work with you on something like that.
Mr. Wellinghoff, Commissioner, Chairman.
Yes, Chairman Stearns. As I indicated to Congressman Barton, I don't have any specific recommendation for you. However, certainly anything that the committee decided to draft, we'd be happy to work with you in any way.
Commissioner Muller.
Mr. Chairman, I generally think government of both legislative and regulatory bodies should periodically review legislation and regulations. So if that's in order, I would certainly endorse that. And as our chairman said, I had a specific example about hydropower relicensing that I'm happy to provide to you. It would be quite complicated given the number of federal laws involved, but any help that we can provide, I'd be happy to do so.
Also happy to work with you, although, as my colleague Commissioner Kovacic pointed out, I think only 4 rules that we have actually are within RegFlex, but we do you know, reg reviews and rule reviews, and in fact we're in the middle of 23 of them now, so I'll defer to my colleague Mr. Kovacic.
Mr. Chairman, if I could just underscore a couple of themes that have come up already today. One, the enormous value of having committees and the Congress as a whole assess before the fact the likely impact in regulation writing of the legislation adopted. Second, the custom you're developing in this hearing of making a regular question for all of us, how much are you spending in each budget cycle, to look at evaluation and the assessment of effects, not just to measure accomplishment by activity itself, but looking at actual impacts, and to press us by asking how much are you setting aside in each budget cycle to do this. And last, we do an enormous amount of work as advocates for competition and better consumer protection techniques before other government agencies, before state governments. And this perhaps provides specific suggestions that we'd be happy to share with you about how adjustments in national and state legislation could improve productivity, improve economic performance.
Okay, my time, I'm going to let the ranking member, but I think each of you have indicated you will help us. You're saying something should be done, so I'm going to presuppose that all of you will submit to us some specifics that we could incorporate and start working as the Energy and Commerce towards this. The gentlelady from Colorado.
Thank you, Mr. Chairman, and I agree. I had asked him for that information earlier, and I really look forward to working with all of you, because as we all said, you know, it's no, actually it was one of you said, the devil's in the details of these regulations. You can say we're all for regulatory reform. We also probably need to streamline some of the statutes, because a lot of the regulations flow from the statutes. And so I think we need to look at all of those. I've been sitting up here thinking about this lead standard with the Cpsc. I was on the conference committee with Chairman Barton and others, and Mr. Chairman, you're exactly right that there was only one no vote on that bill in the House, and Chairman Barton and Ranking Member Waxman and a bunch of us and even the other body sat around for a long time trying to figure out what to do with this lead standard. I remember it so clearly, and when we drafted the new lead standards, what we decided was that determining total lead content was preferable to risk assessment, because what happened with risk assessment is it was dependent on a product-by-product determination, which you couldn't do because of the large number of children's products in the marketplace. And so in addition, although with most chemicals a traditional risk-based model can work, if you have persistent bioaccumulative toxins like lead, Science has demonstrated that traditional models are inappropriate and exposures inevitable. And we spent a lot of time in that conference committee talking about what we do about bikes and ATVs and things like that. So it's not like Congress never talked about these things. I think what we need to do now that we've passed this, and it wasn't one of these provisions slipped in the middle of the night either. We really hammered this out on a bipartisan, bicameral basis. So now I think what we need to do, given the experience that the Cpsc has had in trying to draft the regulations, is sit down and figure out what about that new lead standard might work, what might not work. And this is what led to this effort by then Chairman Waxman last year to develop this legislation everybody's been talking about. The staff undertook a consultative shareholder process with small business and others to try to figure out what we do about the ATVs, the bicycles, the T-shirts with the blue ink, and things like that. He did release a consensus discussion draft of a document to try to figure out how to address these concerns, because we need to do it. But unfortunately, your side of the aisle, Mr. Chairman, rejected that. And so, you know, we can sit down and talk about it. We did do that. We did that when the Republicans were in the majority in the Congress and when we had President Bush in the White House. But we can't devolve to the stage where we say, okay, we're the majority, we're just going to do it our way, and to heck with you, and vice versa. We really need to work together on how to make this work for small businesses and, most importantly, for consumers. So that would just be my, as someone who has fortunately or unfortunately been in those trenches, sometimes these regulations actually came from some scientific basis, and it's going to take some really hard work to fix it. And I think every witness here would agree with that on some of these harder regulations that might be more burdensome. And just one last thing, Mr. Chairman. Ms. Christensen was asking a question about Chairman Ganashowski's efforts to eliminate outdated and unnecessary regulations at the FCC. And he had sent a letter to the subcommittee, to you and to me, outlining the efforts, which noted that they eliminated 50 outdated regulations and identified 25 sets of data collection that are no longer necessary. So, Chairman, I'd like to ask unanimous consent to put that letter into the record.
Well, the gentlelady, let's take a few moments to review it. What is the date of this? I don't see the date on this. It doesn't seem to be. It was today's date. Okay. I would say at this point there's some concern that is really perhaps some of it is applicable, but there's concern on this committee we talked about earlier. The fact that the Chairman Janikowski was invited as chairman to come here. He said he could not come, and so it's customary if he doesn't come, we do not respectfully take his statement opening and put it as part of the record since he didn't show, and we're a little concerned that this might in fact be part and parcel of his opening statement. So I think at this...
Mr. Chairman, I'd just point out it's not an opening statement, it's a letter to us, and we generally...
I think the staff is interpreting as a opening statement, and so I'm just saying at this point we're not in a... At this point we're not able to rule in favor of that, and so I think we're just going to hold off and not put it part of the record, but at any rate, I'll close by saying that civilizations rise and fall because of burdensome regulation. It's in your hands, you people, to do as much as you can to make the small business person succeed so that we can have the innovation in this country. I thank you for your time, and the subcommittee is adjourned.
Good job. Focus, family. It's frustrating on both sides.
I know. Yeah, that's right. Yep.
It's kind of hard to fight.
That'll do it. Yeah, that'll do it.
Yes, you do.
Like a recycling
Put it in the dump.
Beautiful maple.
Yes, you put it in the dump. It's not even unsafe. We haven't even found it's unsafe.